Thank you. Mr. Weiss, are you there? Just wait a moment for the appellant. Does anybody know who's in Haymarket Courtroom?
Yes, good morning, sir. That's myself and the representatives from Historic Environment Scotland. We're using a room audio system.
Okay, thank you. Good morning, Mr. Weiss.
Good morning. How are you? Welcome back.
Good, thank you.
Hope you're doing well.
Thank you. Yes, thank you. Right. Well, we can all see each other, which is great. So I'll crack on. Can everybody hear me before we begin? Brilliant. Thank you. Well, good morning, everyone. My name's Alistair Edwards. I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division. I've been appointed by Scottish ministers to redetermine an appeal by Weiss Development Company Limited against the decision by Historic Environment Scotland to designate the City Sawmill's former office building, excluding the latter 20th century addition at North, at 124 Craighall Road, Glasgow, as a listed building, Category C. That appeal was brought about under Section 5B of the Planning, Listed Buildings and Conservation Areas Scotland Act 1997 as amended. I read parties' submissions together with the previous appeal decision and the Court of Session judgment to quash that decision. Having done so, I carried out an accompanied site inspection of the building exterior and interior, as well as the surrounding area on Wednesday, the 18th of September in the afternoon. I determined that the best way to understand parties' positions and further my understanding would be to hold a hearing session. We're here today to participate in that hearing. I'd like to thank parties for the understanding in postponing this hearing in my absence. Now, before I cover some administrative points, could I ask everybody to introduce themselves, and I'll start with the appellant.
Hi, Jonathan Weiss. I'm here on behalf of Weiss Development Company ready to fight for the Scottish people so they'll have sufficient housing.
Okay, and from Historic Environment Scotland?
Yes, good morning, sir. My name is Cameron Gregg. I'm a solicitor at Morton Fraser McRoberts, appearing today on behalf of Historic Environment Scotland. I'm joined by Mr. Dara Parsons, who is the head of designations to Historic Environment Scotland, and by Ms. Dawn McDowell, who is deputy head of designations at Historic Environment Scotland.
Thank you very much. And from Glasgow City Council?
Good morning, I'm Alison Farrell, the team manager for the Heritage Design and Landscape team within the planning service at the council, and I'm joined by my colleague Shona Simpson, who is the Built Heritage Officer.
That's great, thank you very much. Now, please note that today's meeting is being filmed for live and subsequent broadcast via the DPA's website. And by participating, you're consenting to being filmed and to the use and storage of the images and sound recordings and any information pertaining to you contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. Any information presented to you to the reporter, in addition to forming part of that recording, that will be held as a historical record will also be held and used by DPA in connection with the relevant matter until that matter is decided or otherwise. Thereafter, that information will continue to be held as part of the historical record. Now, are there any questions regarding filming today? No, and by a show of hands, are you all in agreement to being filmed today? Excellent, thank you. Now, we're not today together, so please be aware of any fire procedures in your building. If the alarm sounds, please leave by the nearest exit and assemble outside. We'll pause and or postpone this hearing in the interim. I think you've already understood how to use the microphones, so on when you're speaking and off when you're not. And if you want to speak, then either physically put your hand up or use the hand up raise icon. I'd ask that you keep your mobile phones at least switched off or in silent during today's discussion so they don't interrupt us. I anticipate around half a day for proceedings, finishing around lunchtime. We'll start shortly and have a short mid-morning break and stop for lunch, but only if required. Now, while some of you might be well versed in hearing procedures, this may be others' first experience, and there will likely be some viewing procedures whom an explanation of hearings would be helpful. Hearings are a less formal process where I lead the discussion based on the agenda already circulated. In effect, we'll proceed through the agenda items, and I will direct questions to those present, and that in turn can initiate discussion on a matter until I consider I have sufficient information. The purpose of the hearing is to enable me to obtain the evidence relevant to the proposed development, well, in this case, the designation, so that I can make an informed decision. Those participating should focus on this purpose. I'm not interested in point scoring or needless argument. I'll intervene if I think the responses do not assist me. Furthermore, while there is a legal representative from Historic Environment Scotland today, there won't be any formal cross-examination. While you might be of differing opinions, my focus is that parties discuss matters in a fair and respectful manner. Now, I don't see the need for formal closing submissions, but I'll give parties the opportunity to provide a summary of their case orally at the end of the hearing, should they wish to do so. Are there any questions regarding the points of process or admin? No? Okay. Now, does everybody have a copy of the agenda that was circulated? Okay. So we'll proceed through the agenda. You'll have to excuse me because I'll be typing as we go. Give me 1 second. Thank you. So we've already covered off agenda item 1, an introduction. Item 2 is the remit of the reporter in determining the appeal. So you'll see that I've written out there that under sections 5B and 5C of the Act, what is the remit for me in determining this appeal? Is it to review the decision of Historic Environment Scotland at the time it made its decision, or is it to make a fresh determination based on the evidence available to date? I'll direct the question firstly to Mr. Weiss, and then I'll move around everybody in the room. Yourself, Mr. Weiss.
Okay, thanks. So the remit really of the reporter, both set out in the Act and in the Court of Sessions judgment, seems to be very clear that the reporter itself needs to go back and really investigate the decision of Hess and then come to a determination whether that was the correct decision or the incorrect decision. If it's the incorrect decision, to really quash what Hess did and remove the building from listing. If it's the correct decision, then uphold Hess's decision. Within that, though, there is a case which I'm sure will be familiar with, of Greenland Development Limited versus the Scottish ministers, which made very clear that the reporter's role in report in determining the case needs to be abundantly clear to the unknowledgeable persons. Which really wasn't the case in the previous reporter. Hence, the previous reporter's decision was entirely quashed, and we find ourselves where we do today. But even if you go to the Act itself, in section 5B or 5C, it is very clear that the Scottish ministers, really in their role, which is by the reporter, is to actually go back and determine Hess's decision. If Hess did find the building to be listed. So, in my view, your role today as the reporter is to really go back to the point of time where Hess listed or didn't list the building, and then look at that and decide if that was the correct decision or the incorrect decision, whether the procedure and processes were followed accurately or were not followed accurately, and then to really come to your determination. So in terms of if it's a fresh determination or a non-fresh determination, I think that would be incorrectly categorized. Your role, as I see it, based on the judgments, based on the case law quoted, and based on the Act, is to take a decision which was made by a governmental body like Hess and to really come to the decision if that was the correct decision or the incorrect decision.
Mr. Weiss, could I just go back? You mentioned a court case there. You said someone versus the Scottish ministers. Could you just tell me that reference again, please?
Sure, it was Greenland Developments Limited versus the Scottish ministers.
Was that Greenland?
Yeah, Greenland Development Limited, yeah.
Thank you. Do you have a citation, like a number that goes behind that?
I can find it for you. Give me a second. Just looking up.
Yeah, no worries.
No, I don't have the citation number here, but the same is also established in the Eco Energy Limited versus the first Secretary of State, 2004 EWCA Civ 1566.
Thank you. So on that, Mr. Weiss, if we just follow that through, are you saying that effectively I have a more of an administrative role to look at the process that was undertaken rather than me looking at the whether to list the building afresh?
Correct. Your role is not to list buildings. To list buildings is a role which was given to Hess under the Act. Your role as a representative of the Scottish Minister is to go back and look at the building, whether Hess correctly or incorrectly compiled the list under Section 1 of the Act. If you come to the determination that Hess incorrectly compiled the list, then you as the Scottish Minister representative have the authority to essentially instruct Hess to remove a building from that list. Hess is the body under the Act, Section 1 of the Act, which is responsible to compile the list and really put buildings into the list and take buildings out the list, in their three categories, A, B, C, which we're all familiar with. Your role as the Scottish Minister is not to add any building to the list or take buildings out the list. Your role is to instruct Hess to add or take out buildings from that list. So, I mean, it was also pretty clear to me from the determination of the Court of Sessions appeal, the main reason why that appeal, that reporter's decision was quashed is because she erred in law. She didn't take all of the points into consideration. She didn't do her review work or her administrative work correctly to the court's satisfaction, hence it was quashed. So your role, in my view, is not to add or subtract buildings from the list. It's to simply review Hess's work and come to a determination on that.
So I will come to other parties in a second. I just think it's important to establish this from the outset. So looking at Ms. McCallum's decision notice, which you may or may not have before you, that was BDA-011-2019. And then if we look at the Court of Session appeal judgment, is it the case that where the judges have found an error in law is to do with the processing and whether or not that process was fair and whether or not the reporter investigated that?
Right. She erred in law as far as the judges were concerned, but she didn't take my consideration on board, the fact that Hess decided not to list the building. Again, we can go into the chronology of the events, but I'll just summarize it for this point, as we will get onto the chronology later on in the agenda. But by and large, the way this process worked is Hess decided not to list the building. Then Glasgow City Council served a BPN. We're not getting into the validity right now of it. And then Hess decided to list the building. Now, it was raised a number of times with the reporter, and again, I'm sure you've seen it through all the submissions. The main crux is Hess cannot change their decision so quickly in such a short space of time without anything actually materially changing of the building. Now, the reporter failed to primarily take that point on. It didn't seem like she was taking many points on besides for the information provided from Hess. And again, we can go into her procedure and how she carried out her reviews and how Hess carried out their second listing and all the procedural errors which occurred there. But the main crux is that she did err in law in her handling of the case, in her reviewing of the case, and ultimately in her determination of the case.
Thank you, Mr. Weiss. Now, you can see that the council has dropped off the call. This particular question is not of interest to them, so I've asked Stuart to investigate where they've gone, but we can carry on for the moment. I don't know from yourselves, from the Hess representatives, most of my questions I'm going to direct at Mr. Parsons first, but I think in this instance it's probably easier to go to Mr. Gregg. So, Mr. Gregg, any comments on my role in this case?
Yes, thank you, sir. My clear view in terms of your remit here is that your remit is to make a fresh determination based on the evidence available to date. The legislation itself is in fairly brief terms. We've got section 5B that provides that a person may appeal to the Scottish ministers. 5C provides that the Scottish ministers may dismiss an appeal or allow an appeal in whole or in part. And the appeal regulations set out the grounds of appeal. They provide that the notice of appeal may include as the ground one of the grounds of appeal claim that the building is not of special architectural or historic interest, not to be removed from the list compiled through section 1. So that's the statutory framework we have here. And there's nothing in that that would suggest to me that this is a review process rather than a fresh determination. I would see a review process as being a matter for the courts, really. I'm thinking of judicial review. I'm thinking that it's only the courts who have the ability to review the legality of decisions and that are empowered to quash decisions. A reporter obviously doesn't have the power to quash decisions that went before it. So to my mind, there's nothing here to suggest that this is a review process. This should be a fresh decision which needs to be arrived at on the basis of the evidence available to date. And I respectfully submit that the key consideration in determining the appeal is whether the building is of special architectural or historic interest.
Thank you. I'm just going to double check. Ms. Simpson and Ms. Farrell, you're back in the call now, is that correct? Yes.
Yes.
Okay, brilliant.
Sorry.
Thank you. Good. Just checking. You can put your camera on unless that's going to be an issue. Thank you. So, Mr. Gregg, let's just explore this slightly more. So, I may share my screen. You'll be aware of the Town and Country Planning Act 1997 in Scotland. Yes. So, I'm just going to share this with you. I'm going to ask you for just your opinion.
Okay.
Okay. So, can all parties see that?
Yes, it's coming.
Yeah, so determination of appeals. Now these are planning appeals, they're not designation appeals. But it says here, an appeal under section 47 to the Secretary of State may allow or dismiss the appeal, reverse or vary that. Okay, and may deal with the application as if it had been made to him in the first instance. Now, if we jump here to excuse me, the planning listed building conservation in Scotland Act. It just says Scottish ministers may dismiss an appeal or allow such an appeal in whole or part. It omits the part that says, I may deal with the applications that have been made to him in the first instance. So any observation or comment about that particular difference between those acts? Does that mean anything?
My submission, it doesn't mean anything in terms of restricting the role of a reporter in an appeal such as the present one. I appreciate that we don't have that wording there, but we don't have that wording in a lot of appeal processes. For example, if you think of the role of a local review body in the Town and Country Planning Act, and despite the name, the local review body is making a fresh determination on appeal from decisions by under delegated authority under the Planning Acts. And they're there to make a fresh determination based on the evidence available to date, and that's despite the not having the same wording that they've wanted to when we're dealing with appeals that go to Scottish ministers under the Planning Act. So I think it's an analogous situation here in that we might not have that wording, but we still have an appeal process. And there's nothing that indicates to me that this is somehow a review process with a French determination that needs to be reached.
Thank you. Mr. Weiss, would you like to come back on that at all?
Yeah, in regards to the judicial review points and the legal process, I would respectfully disagree with my learned friend over there. Primarily because if you look at 5C, as you've already alluded to, the Scottish ministers primarily may either dismiss an appeal or allow an appeal. Those are the two options. Now, what appeal are they going to allow? What appeal are they going to dismiss? The appeal on that decision. Now, this dismissal or upholding of that appeal, which is on that decision, that is what they are reviewing. Yes, again, we'll get on if the HES process is a statutory one or a non-statutory one. That's also later on in the agenda, I see. But again, I think this point might be important to raise now, because it's not a question if the reporter's role is one akin to a judicial review or not a judicial review. The reporter's role is solely to go back and look at the appeal, which is an appeal against a HES decision. And again, and my points, which I said earlier, I even cemented further if you carry on in the point of 5C, where the Scottish minister allows an appeal. They may direct Environment HES to exercise its power under Section 1 to amend the list compiled or approved under that section to give effect to that decision, which again would represent that the reporter's role is to review HES decision and guide HES based on his review. The reporter's role is not to become an expert in historical buildings in Scotland and make his own fresh judgments and decisions. It's to go back and review their decisions.
Thank you. Any further comment from any party before we move on in the agenda? Mr. Gregg, yeah.
If you come back in again, sir. Just to say that the grounds of appeal are set out in the regulations, and they include whether the building is of special architectural or historic interest. That's the central issue, which I would suggest that a reporter has to turn their mind to when determining these appeals. And if you look back at the catalogue of previous decisions that have been made at appeal, they all focus in on that question without exception. And they're all determining whether or not the buildings are of special architectural or historic interest. And to my mind, this all points towards the role and the remit of the reporter in this process as being to make a fresh determination based on the evidence available to date. Would be helpful, sir.
Just before I come to yourself, Mr. Weiss, Mr. Gregg, which regulations are you referring to?
The appeal regulations. I can get you the full citation if that'd be helpful. Bear with me.
Sorry, I have three screens. I mean, there's the Town and Country Planning Appeal Regulations 2013 as amended in 2015 to take account of the Historic Environment Act 2014. Is that what you're? Okay.
Yes.
Right. Just one second.
Yeah, and there's a section in that which deals with which covers appeals made under 5B.
Sorry, I'm just looking at those regs now, so I'm just trying to understand.
Yeah, I'll just obtain a copy myself to the assistance.
Yeah, I'll just share this with you again so that I think we should all need to be on the same page here. So let's have a look. So if I scroll up, this is the Town and Country Planning Appeal Scotland Amendment Regulations 2015. And these amend the 2013 regs.
Yes.
And if I scroll down, just tell me if I'm going wrong here. But this is appeals under Section 5B of the Listed Buildings Act, where we're at just now.
Yeah, that's correct.
So where in here is it giving me a list of grounds of appeal?
But subsection 4.
Is it 4? Okay, the notice of appeal. Okay, thank you. Do you see that, Mr. Weiss? Stop sharing and come back out again. I'll let you respond, Mr. Weiss, before we continue.
Yeah, if you just pull that back up, if you don't mind. So over there in section 4, I think it's pretty abundantly clear that again that it's not the reporter's role to go on a hunt for information. The notice of appeal may include as the grounds, one of the grounds of the appeal, that the building is not of special architectural or historical interest and ought to be removed from the list compiled or approved under Section 21 of the Listed Building Act. Again, this would point to the fact that the reporter needs to review Hess's decision and maybe determine if that decision is the correct one or not and direct them accordingly. It's more of an administrative role. I would also refer you to other opinions of the Court of Sessions where it was made abundantly clear that the reporter needs to rely on the information given to him by the parties, not necessarily go digging out new information and review the case as a whole. So again, even what Mr. Gray did mention of previous appeals which were made before the reporter, that the reporter had to look into whether the historical interests of the building were actually of importance or not of importance. That's correct, because he needs to review Hess's decision and understand how Hess came to the determination that this building is of importance or not of importance. I don't know how else the reporter would be able to review a decision if not to understand the process which has to come to that determination. How else would Mr. Gray, assume that the reporter would come to a determination if not to review the information beforehand? That does not mean that it's a fresh determination. It's merely reviewing the determination which has came to determine.
Okay, so to draw a line under this particular item in the agenda, if I were to review the decision, then the outcome would either be, I guess, it would be black or white, either allow or dismiss, and I'd be reviewing the process that was undertaken. If I was to make a determination afresh, then I would have to look at the listed building and its qualities, its special interest, and check that was compatible with a designation, and either allow or dismiss the appeal. And if I was to allow the appeal, then I could direct that Historic Environment Scotland remove the building from the list. Is that your understanding, Mr. Gregg?
Yes, that's my understanding.
Okay, Mr. Weiss, any further comments in terms of item 2?
Yeah, I think your summary really conflates the two and doesn't draw a clear distinction between them. If you are to review a case, that would mean to take the case, to take all of the correspondence within the case, and then to come to your own determination based on that. And as you say, it's a black or white decision. It's either allow or dismiss. If you allow the appeal, then that would follow with your instruction to Hess to remove that building from the list. If it's to dismiss the case, then it would be no instruction to Hess whatsoever, which is again, which is backed up by 5C3, where the Scottish minister allows an appeal. They may direct Historic Environment Scotland to exercise its power under Section 1. There's nothing in the Act which says that if the reporter dismisses the appeal, he needs to instruct Hess to do anything, because there's no instruction. The building's already in the list. Now, if on the other hand, you were to come and determine a case afresh, that would essentially mean that you come to the building with no prior knowledge, evidence, or anything, and you would start to build your own case up and come to your own determination, which again would be contrary to the Act, because you are there to act as an appeal mechanism of a decision which was made. You are not there to come and make your own decision based on what? You have to be there to appeal something. You have to be there to review something which was already decided. You're not there as a new individual to come up with your own determination on the case. And I think that distinction is an important one, especially in this case where Hess decided not to list the building, and then a BPN, valid or invalid, again, we'll get to that later, was served, and then Hess changed their mind. So your decision now is not to come along and decide, whether this building should be listed or not listed. Your decision is to look at the case. I have a not to list determination, a VPN, and then a to list determination. And now I have to decide whether I'm upholding that to list determination or not. And if you don't uphold it, then you have to direct Hess to take it off the list.
Thank you. Any final comments on item 2? No. Well, this, yes.
I think you have the positions of both parties there, sir, but and we'll probably come on to discuss this, but there's also the question as to well, what relevance or otherwise do the previous Historic Environment Scotland decisions and the Historic Environment Scotland decision makings have to the determination of the appeal? And we'll perhaps come on to discuss that later in the agenda.
I have 3 screens and they're on different screens, so that's why I keep pausing between trying to unmute and mute. When you're talking about other decisions, Mr. Gregg, are you talking about other designation decisions, or are you talking about the decisions that Hess made to list this building?
Yes, the decisions that Hess made, the earlier decisions in this process.
Right. Well, I'll have to come to a view on this matter in the decision, one way or another, but unless there's any other points on that. No, in that case, we'll move on to item 3. I'm going to start with yourself, Mr. Parsons. I'm not sure if that's correct or not, and correct me if I'm wrong. We can move between you.
I think these questions for item 3, we propose that Ms. Padal will be best placed to answer those for you from the Historic Environment Scotland side.
Sorry, Mr. Who?
Ms. McDowell.
Ms. McDowell, thank you. Okay, perfect. Right, I'll just change my entries and we'll get that sorted. Right. So, Ms. McDowell, firstly, if you could just take me through the statutory process when a building is proposed for listing. And I assume in this case, the building was sponsored for listing by a member of the public, and that's how it came to your attention.
That's correct. Can you hear me?
Yes, I can, thank you.
Okay, I think the question you've asked is there a statutory process when a building is proposed for listing? There's a statutory duty for Historic Environment Scotland, as instructed by ministers, to list buildings of special architectural historic interest, but there's no statutory process for how that is undertaken. The role of HES in compiling and improving lists is set out in the 1997 Act, and designation is undertaken by ourselves, and the selection of buildings is a process. The functions in relation to listing are set out in the Historic Environment Act 2014. So just to say, there is a duty for us, a statutory duty, but there's no statutory process. The provisions that are set out in the 1997 Act and 2014 Act are supported by policy and procedure that we've established through legislation going back to 1947 for from the date of the first Town and Country Planning Act. So the most recent iteration of our policy and procedure, which explains how we do our work, is set out in our designation policy and selection guidance that dates to the 1st of May 2019. So I think what you might be looking for now is an explanation of the main processes that we undertake in doing our work. Is that right?
Yes, I just want an understanding of how a building, is it one of your colleagues walks past a building and thinks, oh, that should maybe be listed, or is it that there's a mechanism that someone can sponsor a building and flag it for you?
Yeah, okay. So the main role we have in designation is to add, well, I'll speak about listing specifically, add a building to a list, amend an existing listing, or remove an existing listing from the statutory list. And we make minor changes as well to designation records that aren't legal changes to the list. So the priorities for designation is to provide an up-to-date understanding of sites and places to aid the decision-making process about change in the planning system, and that's in reference to listing. So we do this primarily by responding to external designation requests and undertaking projects which we develop to address gaps in our understanding of sites and places. We also, in some cases, develop partnerships by planning and undertaking projects with other stakeholders. For example, we worked with the Cinema Theatres Association to work on a project to list theatres in Scotland a number of years ago. That's an example. But we do respond to external requests. We do not propose listing as individuals within our team without planning a project or some kind of thematic approach to the designation. So individual listing requests are from external members to HES, external members of the public or organizations. They're not self-generated by HES. So going sort of referring specifically to external requests, any person or organization can request a site to be listed or designated. They can also request a review of an existing listing or the removal of an existing listing. And then there's also proposals can be made for certificates of intention not to list. So that's for us to provide a certificate that we would say that a building can't be listed for a period of 5 years. And should I go further with the process itself and how, if an individual application was put to us, how we would process that?
Yeah, I think we're straying into B now, which we'll come to in a minute, because it'd be interesting for me to know how the process worked for this particular case. But if we go back to a person or organization can request a building to be listed, in this case, was it a petition? Was it a community group? Was it an individual? How did it come about in this case?
It was proposed by an individual who is a Minister of Scottish Parliament, Paul Sweeney. And anyone can proposed. So that means anyone such as an MSP or a member of a community group, a member or a local authority, and anybody bar HES basically.
Just for my own purposes to confirm, it doesn't matter if it's an individual, a group, or a petition or anything like that. You give it the same weight in terms of I suppose I should say, is there any vetting process right at the beginning, or do you always look to review a building?
Well, that's something I can get into. I mean, vetting in terms of who's proposed it, or in terms of what's been proposed.
Yeah. So, well, we're straying into B now, but when an application or someone puts, I'm going to call it an application for listing, when someone makes that application, maybe go through the process, is there initial vetting of it to say, is this a legitimate request? Or do you just accept any request and you go ahead and go through your process through your policy of designation?
Yeah. Well, the process. Well, there isn't a vetting process. If a site or a place is suggested for designation, we investigate the site. It's the source of that proposal is not vetted. It becomes like a suggestion, basically, that we will decide based on information that we gather about that site or place, whether if we know about it, is it already designated? We start a process of investigating and understanding what it is in terms of that site or place is what is the nature of that place, and can it be designated as a listed building, as a garden? It's at the very, very beginning. We will have to find out where is it on the map. The starting point is the site and not the sort of legitimacy of the proposal. I know you said we might be talking about this case in particular, but I think it might be helpful if I talk about the application process then, potentially.
Yeah, if you can, that'd be helpful, and then we'll get on to how this.
Because then if I do that, I could refer you back to how this case was handled in the usual way.
Yeah, what we'll do, if you could give me the general, how generally you would process an application. I'll let Mr. Weiss come in case he's got any points about that process, and then we'll look at this particular case for the first decision, and then we'll move through. Thank you.
Okay, so we know what listing is meant to do based on the Act. It's to identify and provide statutory protection for buildings of special architectural historic interest. And the primary purpose under the Act is to ensure that buildings are given careful consideration through the planning system. The intention is to maintain the character of Scotland's historic buildings and prevent unnecessary loss and damage. So that's the position we take. So when we're told about a site, that's where we're coming from. We want to know the level of threat and understand the site and its potential for designation. So when we receive an external request, it normally follows a number of steps that are broadly, there's an application stage, a research and assessment and evidence gathering stage, depending on what our decision is, a consultation stage, and then a notification finally of that decision, that formal decision. Applications for listing are made using our application form. So going back to what in terms of the vetting process, or we need a formal application. We need it done through using our form, and that it gives us the basic information we need to start initiate a review of a site. When we receive that application, we publish it, so it's made public. It's on our portal, and we try to contact the owner of the site to let them know that their building is being considered for listing. Sometimes that's not possible if the place is uninhabited, or it's a structure. It's not a building that can be occupied. In that case, we might put a notice on the site to say this is under review. we also tell the planning authority and any other parties might be affected by it, occupiers, tenants, that kind of thing. So we normally proceed with a review. So at this early stage, unless we find reasons that we might not proceed with a review. And in that case, it might be that the site might be obviously not, it does not meet the criteria. It might not meet the criteria for designation. So it would be something that we wouldn't list, or it's not eligible for listing. It could be like a sculpture in a curated environment, for example, and that would be something that we would, it could be someone would ask us to list something that's not a building, or designation. Another reason might be designation is not the best mechanism, so that's a similar reason why we wouldn't go ahead. It could be a natural environment thing instead of a historic environment thing. Or there's already a certificate of intention not to list in place, meaning we can't list it because there's a certificate. In some other circumstances, we might not go ahead if there are development proposals that are in place, so that we just wouldn't go ahead at an early stage with the review because of those development proposals. However, the usual presumption is that we will proceed with an assessment. That's what we're here for. We're here to provide, understanding about the historic environment. So then that's the sort of the application stage, and then the evidence gathering and assessment is basically what we do. We assess each site individually. We think about our selection guidance, which is published in our policy and selection guidance document. And we would normally visit a site that is proposed for listing. And we make reference to the best available evidence, map evidence, archives, historical information. And we write to people once we've done that research bit and we've come to a sort of an initial understanding. We consider the merit of the building. We produce a report, and we would write to people to tell them if we weren't going to go ahead, if we didn't find this site to be of special interest for designation, or if we weren't going to make a change to an existing designation. We'd let them know that. If though we think there is potential interest for designation for listing, or we propose to make a change to an existing site, an existing listed site, we would then provide a view and proceed to a consultation on that proposed decision. So in consultation, we would consult with those directly affected by the proposal before taking that final decision, and that includes the owners, occupiers, and tenants, and the planning authority. And we welcome views from interested parties and groups. So we publish that consultation report on our portal. The consultation is normally lasts 21 days, but the scope and level of participation in the decision-making process will depend on the nature of the case and the circumstances of that case. And because we want to find out as much as we can about a site before taking an important decision to designate, we allow that process to expand as needed. So, but 21 days is the usual for a case. So once we've received our responses to consultation, or sometimes in the case no responses, we consider whether we should go ahead to list or remove a listing or make a change. And we, in the consultation responses, we're primarily concerned with views that relate to the cultural significance of a building. We also, at the same time, though, consider the purpose and implications of designation, and that's sort of it's part of our policy, which I'll come on to about development proposals and designation. So, in the course of a review, the assessment of special architectural or historic interest is considered alongside a review of the planning context for each site. So, our research and assessment is about the special architectural historic interest, and we need to know where that stands. And then as we're progressing that understanding, we're also keeping. We're trying to also find out what the development context is, because there is a policy consideration that relates to our decision making. And so for the development, when we find there are development proposals that affect a site, we knew there were in this case. I'll go on to that. In our designations policy, it explains what our actions are in that case, or what we would normally do in reference to the legislation. It's very brief, so it says that we can designate regardless of factors such as development proposals. However, we do take a proportionate approach to that, and we act in line with the Scottish Regulator's Strategic Code of Practice. I think we can speak to that later. But what it means usually is that we would avoid intervening unnecessarily in the planning process. So that's why that's set in our policy, where there are development proposals at an advanced stage.
Yeah, that's a really good overview. There's a couple of questions before I come to yourself, Mr. Weiss, and then we can talk about this particular case. Well, actually, my questions do pertain to this particular case as well. But just to check, when is the owner-occupier involved? Is it only at the consultation stage, or are they involved right at the beginning?
It depends. Yeah, because we might have an owner of a building. We know they're the owner, but they might have occupiers and tenants, and effectively, say like retail units, things like that. We probably want to know what our decision will be, or is likely to be at the consultation stage. We'd involve everybody. So, again, initially when we're investigating, assessing, researching with council and the owners, as far as we know who they are, and then we would we would consult everyone who might have a direct interest, meaning they could potentially appeal a decision. So where we'd want them to be aware. So then sometimes we get to that stage at consultation and we haven't gotten everybody, so we have to extend the consultation because we've been told at consultation that there's other people who are owners, or who are there is a parent company sometimes, that kind of thing.
Well, what I'm trying to understand, that sounds like it's quite fluid. I'm trying to understand if there's a time that you must involve the owner-occupier. Is it at the consultation stage, or is there something in your process that says when we get a request, our first port of call, one of the first actions will be we'll look at the site, we'll see if there's any other designations, if it has special interest, get a feel for it to begin with, but then we should contact the owner-occupier? Or do you wait until you've got all the research through and then you contact the occupier?
It can be either or. There's no set.
It's not set down anywhere.
No.
That's what I'm trying to understand. Okay.
It's not set down anywhere. And it's also, according to legislation, there's no need to consult. That's something we've developed over time. We may consult people who have special knowledge, so there is reference to consultation, but there's no, like I was saying, there's a duty to compile a list, but there's no statutory process set out for that.
So I suppose my follow-up to that is, and we're talking generally here, and we can get to the specifics of this case in a minute, but it helps me to understand it. So is it a collaborative process, or do you get to the point where you're like, well, I think we should list this building or not list it. Now we're going to tell the owner-occupier. And at that point, is it hard to backtrack then? Because the owner-occupier may have some relevant information to inform whether the building's listed or not.
No, it's not hard to backtrack if the information that is presented to us relates to the special architectural historic interest that we do want to take that into account. It's not about backtracking, it's about adding to our understanding. So we're very careful to keep the process as open as possible, so we have everybody's views that are relevant to the decision making.
No, that's great. I'm just coming to this again. In this case, there was no certificate of intention. Is that correct? Not to outlist. Yeah. And was it 21 days consultation in this case as well?
It was initially, and then we added another 2 weeks, I think it was, at the end. We had received Mr. Weiss's consultation response, but we had late heard back from, at the point of the deadline, you often hear from people on the day or the day before consultation ends for asking for extension. And in this case, it was the planning authority asking because they wanted to, they hadn't had any response. I understood that internally they hadn't heard anything, and Glasgow City Council it's not just within their team. They let local councillors know about proposals in their constituencies, and they were hoping, and it was over the Christmas period as well.
Okay.
It was just at 9th of January, I think. So the end date. So, and then they were just seeking to see if there's anything further from their council, but there was nothing.
Okay. And when you come to make your decision, is it solely based on the special architectural or historic interest of the building, or do you take into account any other factors? For example, financial or environmental factors or social well-being, anything like that?
No, the decision is based on architectural historic interests. So we in our policy we state that condition is not a factor unless the condition of the building is such that there's not sufficient fabric to evidence its special architectural or historic interest. So that one is probably something that we need to dive into to figure out. And especially when a building is not in good condition. However, financial matters, future use, building not being in its original use is not a factor.
Okay, and as a public body, you wouldn't be weighing up the socioeconomic, environmental effects of your decision making?
I think where we arrive at that is through all of the things that we put in place to assess. We're here to help protect the historic environment. We take on board, anything that relates to the special interest, and then within that, we assess whether or not there are proposals already that are in place that affect the development of that site with it. So it's very much we're down the funnel. We've got our historic environment policy, and then the development, the designation policy fits under that, and then we have a specific remit to look at the buildings that are special architectural historic interest. So within that, it becomes narrower what our role is.
Thank you. We'll come back to the Scottish Regulators Code later in terms of decision making, but just as a general, that's interesting to know. Mr. Weiss, any comments on the general process, and then we'll get to what's happened in this particular case?
Yeah, Mrs. McDowell definitely raised a lot of points for this point, but I'll try to mark them off, one by one. Firstly, in regards to the core question which you ask, is the statutory process of listing the building. It's very clear from the HES website. I'm happy to share the link with you. And it reads as follows: proposals must be made using our application form. Application forms will be published on our portal and will include your name, address, unless you opt out. Now, if you look at the application form itself, it's very specific in the application form that they don't even accept the application form by post, only by email. So to answer your core question of how a building comes to be listed from the outset, it's by an application form being submitted via email. That's the answer, full stop. Now, in terms of this case initially was applied for by Paul Sweeney. Initially, the application form was redacted. Later in the proceedings, it became unredacted and became obvious it was Paul Sweeney which actually applied for the initial application form. The second listing was never applied for by any application form whatsoever, which is contrary to the HES guidance itself. The only way that it was applied for was by email of Glasgow City Council informing HES that a BPN has been served. And again, you can look at the chronology. I'll be happy to take you through that. That is in my note of argument to the Court of Sessions. You can see that no BPN was actually served at the time when HES confirmed that they're now re-looking into it as a result of a BPN, which was never actually served. When it was ultimately served a few weeks, even months later, it was completely invalid. It wasn't correctly served. Later again, due to my freedom of information request from Glasgow City Council and HES, it was actually revealed that Glasgow City Council has no idea how to serve a BPN, and they were literally, it was a ping pong match between the departments over there of what a BPN even consists of and how to serve it. Again, this is all in my submissions. Now, I'd be happy to pull them out for you, to show everyone here, but I believe everyone is well versed with my submissions, with the evidence which was before the court, before the previous reporter, and in every instance where HES has requested information from myself. Now, in terms of us being made aware of HES to look into the building as a result of a redacted application form, the process was very fluid, to put it politely. As Mrs. McDowell, explained, there is no formal process where they have to let the owner know, even though it's something to do with his building, which is, again, contrary to the Human Rights Convention, which I did put into my submissions again, because it is a property, and that property is a personal effect of somebody, and any legal change in that is an effect on his human rights. Again, I can send you later on the chapter and verse of that, which he legally doesn't need to be told about. So yes, it might not be in the Listing Buildings Act, but it is in the Human Rights Convention, which they HES should be well versed in, especially as they are affecting people's properties day in, day out. Now, when it comes to this particular matter, again, Paul Sweeney applied under redacted application. HES obviously dealt with it the way in which they did and came to the determination not to list the building. Now, again, this has been shown to the Court of Session, but I believe it's important to, again, point out, especially when we're all on one call, the designation application form is one application form to list a building, to ask for a certificate not to list a building, and for all the points mentioned on page 3 of the application form, which is to assess the site for designation, assess it for designation after a building preservation notice has been served, review its existing designation, remove its designation, issue a certificate of intention not to list, make a minor change. So it's one application form for the whole thing. So essentially, when HES decided not to list a building, again, we can get into the legality of Section 5A, which I'm sure Mr. Gregg is keen to get his teeth stuck into, if it was a coin tool or wasn't a coin tool, which is irrelevant for this particular point of the agenda. The point is that it's one application form which has only ever been submitted by Paul Sweeney, has never received an application form by Glasgow City Council to review it after a BPN, and was solely reviewing the case based on an email, which it itself confirmed it never received the BPN in that email.
Great. I'm going to ask you a couple of questions, Mr. Weiss. think we're going to get into the specifics now. That makes sense. But I'm not sure if it's Miss Farrell or Miss Simpson. You had your hand up.
Yeah, it's myself, Alison Farrell. Just to note that Glasgow City Council did two things. There was an email from the head of planning, Sarah Shaw, to HES, which was followed up with the online application form for the listing application. So we do have records of that being submitted as part of PN process that we pursued.
Let's step back. Which one are you talking about? Are you talking about the first review or the second review?
No, the second one, following HES's initial decision, where they said it did merit a C listing, but they declined to do it because of the development proposals. So the action that took place after that, whereby we then signalled our intent to pursue a BPN.
Okay, so we were going to come to this later when we go through that process. It's just a few down on the agenda here, but what you're telling me is that there's an email from the head of planning to HES. Is that correct?
Yes, a formal letter. Yeah, so it was a letter attached to an email, a formal communication from our head of planning to let HES know
about the BPN.
Yes, and yes,
to assess the building for listing as part of the BPN process.
Okay, thank you. We'll come back to that. I think that's important. Mr. Weiss, you can come back in now.
Another point, Miss McDowell did mention on the second process that they added another 2 extra weeks onto the consultation period after the 9th of January. This is again evidenced, via the Freedom of Information request as to why they did it, because simply Glasgow City Council couldn't muster anyone up to write into HES. And as a last-ditch attempt, they asked HES to extend the time to try and get some sort of submissions. Even Councillor Go, as I'm sure you've seen in my submissions, even questioned Glasgow City Council as to why on earth they're pursuing this and why no councillor was in fact consulted prior to the BPN. As we're all aware, and it's also evident in the emails, internal emails of Glasgow City Council, they are fully aware of the repercussions which come out of the BPN if HES decide not to list the building. They are legally bound to pay compensation for it. And again, we will get to it later on in the agenda as to when the BPN exactly was decided to be served or not. But I think it's important to note that as fluid as the mechanism of HES is, HES itself doesn't follow its own fluidity. It seems to be, adding channels and deciding what it wants to do as it goes along. And on the point which Ms. Farrell raised about the email, I believe I did mention that email. The point in which I mentioned is that no application form was ever received by HES, or not that I'm aware of. I've never seen such an application form, and I've personally been dealing with the case now for quite a while, and I'm very well versed with all the paperwork. I've never received such an application form, or haven't had sight of such an application form from Glasgow City Council to HES, and that is the only way, according to HES, which it decides to review any BPNs or applications from members of the public or organizations, is solely by an application form being sent by email, not by formal letterheaded emails sent to HES.
Okay, before I come back to yourself, Ms. Farrell, let's drill down in that. Ms. McDowell, is that correct? Is that the only way that HES will entertain an application is through the online submission of the application form, even if there's a building preservation notice in play?
Well, they don't happen that often in terms of the building preservation notice, but that's the way we prefer to have an application sent to us. Some people don't have access to digital, so we would then print off the application form, send it to them, they'd post it to us. Sometimes people can't write their own application because they're not able, and we would ask we would talk them through the application sort of information and that we request for that review, and then we would, make it, validated, I suppose, based on that. So,
but in this case, what Mr. Rice is saying is that didn't happen. That what happened when I know we're jumping forward here. We're talking about the second process, but he's saying no. What happened in this case was that the head of planning sent an email to HES with a formal letter attached to it. Is that a proxy? Is that? Would you entertain that?
That did happen, but we asked the council then to send us a formal application using our form, which they did do. And they sent that to us on the 31st of October, 2022. It should be here.
Thank you. So, Ms. Farrell, do you want to come back in there? Your hand's still up.
Yeah, so just to reiterate what Donald said, that we did submit the relevant form to HES as was required at the time, and also to note that our head of planning, Sarah Shaw, did brief the relevant conveners about the BPN before it was served, so there was communication in the relevant. Which was accepted. Right. Yeah.
Apologies. On what date was the application received by HES?
The 31st of the 10th, 2022.
And while you're looking for that, Mr. Weiss, Ms. McDowell, could you just take us through then the process of this application? What happened initially here? So I understand we got the application from Paul Sweeney, MSP. It's come in. I don't know who it goes to. So let's talk through the process. Who did it go to? What happened? And ultimately, why did you decide not to list the building at that stage?
Okay. So we first received the application from the interested party, Paul Sweeney, in May 2022. And we published that application on our portal. And we got in touch with the agent for the site, who is handling the site, I guess acting on behalf of the owners. We didn't know at this stage who was who yet. We visited the site in July 2022, and we saw the exterior and the interior of most of the buildings except for that late 20th century extension. We didn't go inside that building at that time. We then assessed the building as explained using our selection guidance and found there was potential for designation for listing. Our decision was not to list the building because there was a planning, because there was the site was subject to development proposals which were at an advanced stage. We found that there was an application for demolition for the erection of residential flats. So the status of that planning application at the time of our decision, or when we were just about to make our decision, was pending consideration. And in line with our policy, we found that meant that those development proposals were at an advanced stage. We consider the individual circumstances. So, and in that case, that's what we decided. So, so I can tell you about, what the decision making is in reference to the what we do consider what means advanced. If you know what I mean. Like if we get to that stage of saying, well, there's a planning application here, what is?
I would appreciate that because you just said there it was pending consideration. So I don't know if that's is that your line? I'm trying to understand is it pre-application consultations come in for it? Is it that it's designated in the local development plan? What is it that advanced stage means?
Yeah, well, I'll just explain it in reference to this one. So yes, I mean, when there is actual application in, that is definitely considered advanced. When you get to a pre-app stage or local development plan, you have to look into, like, speaking to the local authority, what do they understand, what has been potentially consulted on in a public way. So there, I think Dara and will be potentially talking about this because you have questions in the agenda about that. So, but I think in reference to this case, I'll just speak to what we decided here. So we look at the implications of a designation on the development proposals. So what would it mean if this building was listed and there are how would it affect the development proposals that are put forward? So in this application, demolition. So once a building is listed, there's a strong presumption against demolition. So and the application was for demolition, and we found it was of special interest, but our designation obviously would have a significant impact on that proposal because it was for demolition. The other thing, it could have been a minor thing. There could have been a change to the rear, and we think maybe the designation wouldn't have a huge impact on the proposals. So for us, that sort of leads us into thinking, well, that's advanced. Our designation means that building, because there's a strong presumption against demolition, that means it would affect that development proposal. And then in the reverse, the effect of the proposal on the actual the significance of the site. Well, full demolition means there's going to be no building, so it's self-evident that the building would be lost. And then the extent to which plans have been developed for the site and where these are particularly advanced, we will not normally list, but we feel that this was in play. So something that's in play to that extent is for us a significant factor. Although, yeah.
Yeah, no, that makes sense. So in this case, there was an application in with the council, and it was an application for demolition and then flatted development, I assume. And it was still to be determined at the time you made your first decision. Now, there's an interesting question here that comes into my mind. So why would you not intervene? It feels in my mind that there's an economic or fairness consideration that you're applying here. Is that the case? We're talking about why is it that advanced stage would preclude you from listing the building?
Well, that's sort of the whole point of us taking a proportionate view about not intervening unnecessarily in the planning process. It's in terms of fairness and proportionality of our decision making and where we would intervene and present a burden or a barrier within that process that didn't exist when that process began, and it's where we come in at that point. So we feel that's advanced. That's why we use the word particularly advanced. However, each case is looked at individually, and we will take a view based on the circumstances of each site. That's how we can list anything basically, but we don't feel that that's proportionate.
Okay, and then I'm jumping ahead in the agenda. That's how hearings work sometimes, but we can circle back to this later. But that particular proportionate response, that doesn't apply then when there's a building preservation notice in play.
Well, we have to take into account again the whether or not with all the information that we're given, with the buildings of special architectural historic interest, and in terms of there's no policy impediment to proceed with when in the context of a building preservation notice. That's why it's there. It's where there is potential loss of heritage that in terms of the special architectural or historic interest that would be, I suppose, at risk, and then it changes the policy context for us, and we would then be able to proceed in policy terms to designate.
I realize we're jumping ahead. This is probably at the crux of a lot of this here. I mean, you've said there policy change. I'm trying to understand what did change between. So there was advanced stage proposals on the site. Why is it that your policy then provides a different take on it if there's a building preservation notice when you've already made a decision not to list the building? Did the advanced proposals fall away? Was the site no longer being promoted for development at the point that you went to list it?
No, but that's precisely the point of a building preservation notice. It's there when there is buildings that might have planning affecting them, or they might be in a different process. They might be in an appeal process, and that's something that we would, we could proceed with and that building preservation notice is in the legislation for a reason. It's for in those specific circumstances where there potentially is a loss of a building, or it might be altered to a point where that it wouldn't be special anymore. And it is brought to the local.
Sorry to interrupt, but wasn't that known when you made your first decision that the building was at threat? I mean, you said in your first decision the building has value enough to be designated, but we're not going to designate it because there's advanced proposals. Why would hadn't you already made that decision? I'm trying to understand what changes when there's a building preservation notice in play.
It's the local authority who intervene in the process, in the planning process. It's not for us to intervene, it's for the local authority to intervene and to take a view on them. And then they signal that through the serving of the building preservation notice. We do not serve building preservation notices. That's not our role.
Well, I wonder, Mr. Parsons, do you have anything to add to that? No, I think we're sort of jumping around a bit in the agenda.
Yeah. I mean, what we can circle back to this. I think, let's circle back to it. I think it's an important thing for me to understand in terms of. So let's go through it here. So in this case, the first decision, there was an advanced stage application on the site, and for that reason, it wasn't designated. And I asked, is that because of economic or fairness considerations, maybe socioeconomic? And the question, the answer back was, you take a proportionate view based on the planning process, and you don't want to burden or place a barrier on that process. And I said, but that seems to change when you have a building preservation notice in play. But in this situation, I was trying to understand what has changed that has allowed that, other than the local authority who were already involved. They were already involved in the first consultation, and indeed you extended the consultation period by 2 weeks to involve the planning authority. So I'm trying to understand why you would have already known that the planning authority, their view. I think perhaps I'm going to let Mr. Weiss come in here, and then we'll have a break, and I think we'll come back, and then we can delve into this a bit further in the rest of the agenda questions. So, Mr. Weiss.
Yeah, thank you. Just to touch on the last few points, as I believe this is really the crux of the hearing. Until now, it's been the fluff on the surroundings. The real crux over here is that there was no material change. And even in the event that, as Ms. McDowell says, their change now was the building preservation notice. And that's why now they had the authority to list the building. I would actually point her to their own guidance in the interim guidance on the principle of listed building consent. In point 15 of that guidance, it is very, very clear that even after a building is listed and there is sufficient economical benefits or benefits for the surroundings to demolish a listed building, part 8 of that guidance falls away. So even in the event that Hess's only point to rely on was a BPN. That in itself is false to have been relied on. Because even after a building is listed, if there are sufficient economical reasons to demolish it, it gets demolished. And Hess knew, as you did say, Mr. Edwards, from the very outset, Glasgow City Council's position about wanting to serve a building preservation notice and being pressurized by Paul Sweeney, MSP, which if you've Googled him up, you'll see he's very active in listing buildings and does act on quite a number of lobbying and pressure groups. So they did have sufficient pressure on them to serve the BPN, yet Glasgow City Council didn't do that, and Hess in turn decided not to list the building. So for Hess to now come along and say that their only change was a BPN, that itself is a false pretense to have listed the building, because there's enough economical development opportunity over there to add 60 plus social flats to the surrounding area, which is in dire need for those flats, not to list the building. Now, between Hess's first decision not to list the building and the service of again, in my opinion, an invalid BPN by Glasgow City Council, Ian Briggs, which Miss Farrell and Miss Simpson will confirm is quite high up in Glasgow City Council's planning team, requested further reports from us to advance the planning process even further. So this whole thing, again, I'm reiterating this because I feel that this whole thing has been a sham in a way. They've had external pressures being applied, and none of the legal processes have been considered over here. Hess decided not to list the building, which was in an advanced planning stage. Even today, if you go on the Glasgow City Council's planning portal, you will see, let me open it up so I'm quoting it correctly. The demolition of existing building, the determination is still declined to determine. They've declined now to determine it, but they have yet to withdraw it or to refund us any of the fees to materially symbolize that they have declined to determine it. So this whole process, in effect, there has been no change between the first and second determination. The BPN has been an invalid one. I to date haven't seen that second application. I'd be happy in the break to review that if Miss Farrell or Miss Simpson send that to my email, which they do have. And if the changes which Miss McDowell relies on for the second case are frankly are forced to be relied upon.
Okay, thank you. Sorry, I'm just going to ask a quick question of the council, and then we'll come back to this particular point, and then we'll take a break. So, sorry, Miss Farrell or Miss Simpson, the application, the one that was for demolition and residential development, what stage is that at now?
So, as Mr. Weiss has pointed out, the council has the status on it have been declined to determine, and that was due to the failure by the applicant to submit the PAT report, and that was the route that was taken. So there is at the moment no live consent or current application for the site.
Sorry, let's just hone back on that a bit. I'm struggling to understand. So this is the same application that was in 2022 that prohibited the building being listed.
Yeah. So I can give you the reference number. Do you need the reference?
No. I'm just trying to understand. So
yeah. So I can give out to you what the development management manager provided myself. Information Ian Briggs, who said that. So the section 39, 1A of the Planning Act requires the planning authority to decline to determine an application to which the PAT requirements apply and where the applicant has not complied with those requirements. The planning application was originally validated on the 10th of May 2022. However, the required PAT report, so that's the pre-application consultation report, was not part of that submission. The council made the decline to determine decision on this application on the 15th of December 2023, following a series of unsuccessful requests to the applicant's agent to submit the required PAC report.
Okay, so hang on. So it was validated on the 10th of May 2022, but because the PAC wasn't there, the council declined to determine it a year and a half later. Is that correct?
Yes.
Well, what is that not part of the validation process when the application is made? I don't quite understand why. And Mr. Rice has also said that the planning officer was requesting additional information later on in 2022. Why? I'm trying to understand why this application was still with you for that length of time if it was missing a vital component.
I think he was probably waiting for the outcome of the STEM discussion.
Yeah, so we presume that the development management manager was waiting for the outcome of the listing decision before progressing with things.
Sorry, just to come in on that's actually incorrect. The reason that it took them that long is because for such a large project, you don't just wake up one morning and submit an application to the council. There is a whole pre-app process. There's many reports which you have to do prior to even coming along and submitting such an application. Now, I was on a Zoom call in November 21 with Ian Briggs, which is actually overseeing the whole project, which is evident from the letter which Ms. Farrell just pointed to. And he actually apologized for him personally being responsible for the delay in all the pre-app process until that point, and that now he'll advance the stages. Now, those reports between the first HES designation and the BPN, some reports had already expired. Those reports, some reports are time sensitive, they're only valid for a certain amount of time. So those additional reports were actually requested again from us for us to remake those reports. Now, the decline to determine, again, was only in 2023, as you can see email from Paul Sweeney around about the same time, to basically try and twist the reporter's decision into being that now that there are no advanced applications, therefore the reporter can now go ahead and list the building. And that is exactly why I stress the point that the reporter's view and decision is not today. The reporter is not there to determine the case today. The reporter is there to go back and see what HES did and to review HES's work at the point at which HES did their work. The reporter is not there to look at the case afresh today. And that is an integral difference between my understanding and Mr. Gregg's understanding. And if you go with Mr. Gregg's understanding, then no reporter will ever be able to correctly review any case, because he would always be at a different time point when reviewing that case. And therefore, my view in the matter, that the reporter is actually there to review HES's case at HES's date, is consistent with the statute and consistent with the judgments, both in my case and in the case which I pointed to earlier. And the council, again, it's very unfortunate that only Ms. Farrell and Ms. Simpson are on this call. As Ian Briggs, he's not just a paper pusher in the office. He's quite senior and should have actually, if anyone from the council been in this meeting, it should have been Ian Briggs, as he would have been in a position to answer all of these questions and to attest to what I am actually saying.
Okay, but a couple of follow-up questions there. Mr. Rice, in that case, are you saying that I should disregard any material considerations or any material factors that have arisen since HES made that decision?
What I am saying is that you need to go back to the point in time which the court directed you to do, which is to review HES's second decision and what material change happened between their first and their second decision. Any other change, be it the decline to determine, which happened in December 2023, is irrelevant to you, as that is not, you are not reviewing the case on the 25th of February 25. Yes, we are having the hearing today in a point in time, roughly 2-3 years ago. That is what we are doing. We are not reviewing today's case today.
Okay, I'll come to yourself in a minute, Mr. Gregg. Finally, to the council, just a question about the current status of that application. Mr. Weiss has said that although it's declined to determine, the fee has not been returned. What does that mean? Does that mean the application is still live, or is that correct?
I can't answer that, Mr. Edwards. We would need to speak to Ian Briggs, but as far as I understand it, declined to determine means that the application is no longer live. But the fee matter, Mr. Weiss would need to take that up with the planning service directly, like with these proceedings.
Okay, Mr. McDowell, and then I'll come to anybody else, and then we'll have a break.
Okay, I just wanted to say that before we took our first decision, we were aware that the council were considering a BPN, but we did not know their view, and we did not share any views on special interest or what our decision would be. We were just saying, we were telling parties that we were considering the building for listing. And I think in the same regard, the council said they were looking at a building preservation notice, but there was no point where we discussed, when those decisions were going to take place and what those decisions were. We could not have done otherwise in our first decision. To see that the building couldn't be listed in our policy terms.
Sorry, just on that, because if I don't ask now, I might forget later on. It's important. I think that your policy says generally doesn't say this isn't a black and white situation. So you could have determined that the quality of the building was such that despite the advanced planning proposal, you could have listed it. And in fact, you said to me before that the Act doesn't put in any restriction on advanced development proposals. So is that correct?
Yes, but our practice is not to normally, and we know that there could be challenge on that basis, and that has taken place in the past, where we would not normally proceed when there are such proposals in place, and therefore the decision could be overturned or legally challenged through like a judicial review, for example.
Yes, Mr. Parsons.
I'm not going to mention. I think we have to come back to all of this later. I just wanted, for the benefit, reporter to point out that the application form submitted by the council is already before you. I can give you the reference if that's helpful. So it has our BTP-03 is and that has been part of our document submission since the very start of the process. And there's never been any doubt about the existence of that form. I think the helpful to move on from that.
Okay, so sorry to just jump in. Mr. Parsons, do you have my email address?
I don't know. Sorry.
Hey, you want to take it down and send me the application form?
It's on the DEPA website.
If it's a submission, then I can share it with you here. And Mr. Weiss, you could have a look at it on our DPA portal. Let me just get sorry, what was the reference was it RBTP-03?
Yes. It's referred to in our submission. If it's not on the portal, that we can certainly send it on now, but it's in our submission.
No, I have it here. I'll just check this is the one. Right, I'll just share this with you just to check that this is the correct one. So I think this is the form that you're you've directed me to. And that's from yourself, Miss Farrell. There we go, and that's the property there. I'm assuming there's a date in the bottom of this as well. So we'll just scroll to the bottom.
There's no date on it.
No date, okay. Okay, well, that is the application form. So Mr. Vice, it is available on the DPA website. Okay, any further points in terms of 3B?
I'm just going to come back, sir, on the comments which Mr. Vice made. I mean, we're revisiting item 2 again as regards whether this is a review or a fresh determination. You already have my position on it. My strong view is it's a fresh determination here, and my view would be that if we were to just disregard any changes, for example, to the fabric of the building, then it could lead to an absurdity if we're simply reviewing a decision from some time ago, not having regard to the current architectural or historic interest in the building. But you have my suspicions on that.
Okay, it's 11:40, so we can come back at 5 to 12, and then looking at the agenda, I think my preference actually, if we come back at 12, so you get a slightly longer break now, and then I think we'll probably look at half one to finish the hearing. Okay, so we come back at 12. Much appreciated. Thank you.
Thank you.
Welcome back, everyone, if you're there. I'll just let you get your cameras switched on. Thank you. Stating the appellant. Rice, are you there? There we go. Perfect. Well, welcome back, everyone. We're on to item 3C. So I'll just confirm, this should hopefully be very quick, but Ms. McDowell, you just confirm that the initial decision by HES, it didn't prohibit the issue of a building preservation notice. Is that correct?
That's correct. There's nothing in legislation or policy to say that a further review couldn't be carried out, and nothing to say that a BPN could not be served. And there was no procedural reason that a BPN could not be served.
Coming to the council, Ms. Farrell, Ms. Simpson, could you just explain to me the statutory process for issuing a building preservation notice? I think it's section 3 of the Town and Country Planning Act 1997 as amended.
Okay, so as you said, under the 1997 Act, where it appears to a planning authority that a building within their area is, which is not listed, but is of special architectural or historic interest and is in danger of demolition or of alteration in such a way to affect that character, then we may issue we may serve a building preservation notice, which is effectively it has the effect of listing for a temporary period of 6 months, during which time then we would ask HES to consider the property for the item for listing. The notice will state that the address or the subject is of special interest, and that HES will be asked to consider it. I think that's it, really. It's the notice itself is served on the owner through our enforcement service, who will have issued that notice through the sheriff's officers, and also to any other interested parties. And in this case, that was the agent to do with the land planning application, or any occupiers of the property. I should say it's a very infrequent procedure for us to be involved in, as HES also noted.
Okay, and as a quick follow-up for me, could you just explain the timeline? So we've got HES's initial decision not to list. How long was it until the building preservation notice was issued? What was happening in that time frame?
So the building preservation notice was issued on the 18th of October 2022. And the letter that we spoke about earlier from the head of planning had been issued prior to that on the 16th of September 2022. Yeah. So effectively what that does is that allows the property a period of time in which HES can then consider the listing proposal.
Okay, and just to get the chronology here correct, so it was the 5th of September 22 that HES declined to list the building. And then 11 days later, head of planning writes to HES saying building preservation notice. And 2 days after that, the building preservation notice is served. Is that correct?
The building preservation notice was not served until the 18th of October. Yeah, 18th of October.
Yeah, sorry, 1 month and 2 days later. Yeah. Okay, but it was, so HES made their decision on the 5th of September 2022, the initial one.
Yes, which stated that in their view, the property did meet the criteria for C listing. So they stated that it was of architectural and historic interest at that point, but declined to list it because of their policy in terms of advanced development proposals. So that signalled to us that the property was of architectural merit, and so in order for us to afford that property some level of protection in the interim, we then had the option of serving a building preservation notice, which then there's a different, as my understanding of it, is a different set of circumstances for HES to look at it.
Okay, I mean, that neatly brings us on to the next item on the agenda then. So what was the reason that you served the building preservation notice? You've just indicated there that it was because HES had indicated that the building did have special interest.
Because the property, because the property was found to have merit and was of architectural and historic interest, and also in terms of the 1997 Act. The second point being that it was potentially in danger of demolition or alteration, in which case it would be lost. So there was the opportunity there to put a measure in place to afford it some time so that HES could look at it further.
And you were involved, maybe not yourselves personally, but Glasgow City Council were involved in the initial listing decision with HES.
No, well, not so.
But you were consulted.
So we were consulted to, so I think maybe there's a wee bit of confusion about those consultation periods that you mentioned earlier. The HES had notified us that they had received an application for listing and requested any information that we had about the site in terms of those development proposals. So that was the first instance where they requested information from us at the beginning of their processes. The consultation period that was talked about earlier, where there was an extension to that consultation period, was a different situation whereby that was after the second assessment by Historic Environment Scotland, after the BPN had been served, the second assessment by Historic Environment Scotland, where they were going to list the building. There was a consultation period, which was quite a wide consultation that they carry out when they are going to list something. That was much, much later in the process.
Oh.
What was said just now was just that there was no consultation on the first decision. It was we just said we provided a report and we published it. We had gone to site, we had been in touch with the council and the owners, and Mr. Weiss would have been aware of our interest in assessing the site in July, and in that, from after this the site visit, we prepared a report, and that was published on the 5th of September with no consultation on that. The information exchange between us and Glasgow City Council in that interim period was about finding out what the development proposals were, and just getting the information about the planning application.
Thank you. Mr. Weiss.
Thank you. There's an email on the 22nd of June 2022, an internal email of Glasgow City Council, which claims that they'll be visiting the site with HES on the 12th of July, and informing, well, Glasgow City Council of the dangers, in quotation marks, of serving a BPN notice at this stage if HES were not to list the building. So for Ms. Simpson to say that they weren't aware, weren't consulted, weren't anything, again, it's completely false. It's been proven from their own internal emails. The council visited the site on the 12th of July. They clearly were in internal discussions about the BPN. They were made aware of the dangers of serving a BPN if Hess would not list the building, and hence they didn't do so. Furthermore, the email, again, I'm going back to the email because I believe it's important to stress over here the internal mess and turmoil the council itself were in, and the evident external pressure which they had applied upon them and in turn applied on Hess to ultimately list this building. Had the council wanted to do so, we initially started speaking with the council in 2018 about these proposals. It wasn't fresh proposals from 2022. You know, Paul Sweeney came to the scene in only about May 22. That's not when the actual proposal started. Initially, when we even started out speaking with the council, our then planner, David Sinclair, emailed the council to ask if they have any interest in the building, which they didn't have any interest in the building back then. And again, we opened their eyes to ask before we invested these hundreds of thousands of pounds in all these reports and planning applications to investigate whether there was interest or wasn't interest in terms of historical importance in the building, which there evidently wasn't. So all of these things, you know, which the council is saying we didn't know, we weren't aware, we weren't sure. Again, there is black and white evidence to the contrary. They were aware. They visited the site with Hess. They were aware why they didn't serve the BPN. Again, Ms. McDowell, I see you're nodding, but have you seen their email of the 22nd of June 2022? They did visit the site. They were aware of the consequences of a BPN. They were aware of all this. This is evidence. This has been filed in the courts as evidence. So I don't know how anyone even has the audacity to come online today to refute this, unless I was sent fabricated emails.
Sorry, Mr. Weiss, just for my note here, you said, when did the council visit the site with Hez? Got the 12th of July.
Yeah, that's in their email dated the 22nd of June that they're scheduled to visit on the 12th of July.
So they're scheduled to visit, okay.
This is in submission TL4, which I submitted to the court.
Okay. Ms. McDowell, I'll come to you, then Mr. Parsons, then I'll just clarify with Ms. Farrell whether the council did visit the site.
Yes, the council told us they were going to visit the site, and we said we won't visit the site with yourselves. We have our own process. We would visit. We have made arrangements to visit, and it was on the 27th of July. And so it was just information that we had that we knew they were going to be on site for I guess the reasons where they were considering a BPN. We'd never, in any course of up into the decision of September 2022, discussed the merits of the building. Simply the processes we were going through. So we were letting the council know what date we were going to site, and that we would not accompany them at the same time. We're very clear about that, and that's how we would normally proceed.
Thank you. Mr. Parsons.
Oh, it's just, Mr. Weiss has referred to some internal council emails. I wanted to, I suppose, just clarify that. I don't believe they're before the reporter, and certainly from an S point of view, we haven't had the benefit of seeing that freedom of information requests. We don't have those emails. I think if we're going to discuss internal correspondence of the council carried out, I think we would want to see that. I don't think it's reasonable to start to, suppose, discuss the council pressurizing Hess in that context or anything like that. This is internal council correspondence.
Sure. Well, whether or not it's before us, there's different options if it's not before us, and I don't want to prolong this decision any longer than need be. I think we could probably take it as read. I mean, the council is not, or are you, Ms. Farrell, declining or refuting the fact that this email was sent? Did the council indeed visit the site on the 12th of July?
Yes, we visited the site in July 2022, yeah.
Okay. So you did visit the site before the BPM was served.
Yes.
And what I'm trying to understand is, was that the heritage side of the planning authority, or was it the planning officer that had the application? Did they attend as well?
It was, yes, it was the heritage team and the development management team. So Benny and Bruce.
Okay. During those visits, you visited inside and outside the building like Hez had done?
We visited internally and externally to the building, yes.
Okay, so in summary, in this item, the change in circumstances, as it were, that proceeded to the building preservation notice being issued were that the council then had an indication from Hez that the building was of special quality. Is that correct?
Yes.
Okay.
We visited site. Sorry, we visited site in July 2022. HES had obviously undertaken their initial assessment, and then they had let everyone know about their initial assessment, and we agreed with them that the building may merit listing.
Okay, so at that point, obviously, the council were aware that Hez had determined not to list the building for the reasons given with the advanced planning application. Was that a reason or a consideration in the council when they made the decision to serve the BPN? Did they consider, well, we've got a planning application here? Did you feel that that was a burden or barrier?
Well, in many ways, the planning application for demolition in itself is that puts the heritage asset at risk by definition. And so there was a degree of clarity then at that point in terms of the architectural quality and historic interest.
And it was felt that there needed to be full clarity on the listed or otherwise status of the building for the planning authority's development management assessment of that live application and any future applications for the development of the site. There's also the council's responsibility through the stated aims of the city development plan to protect, conserve and enhance the historic environment. So the fact that HES had made their initial decision to say that the building merited listing, it was therefore felt that action to serve the building preservation notice could allow HES to fully consider the listing of the property and provide that clarity for the development management process.
So there's just two questions in my mind here. So the first one is, the council was obviously aware of the proposals in 2018. Mr. Weiss has referred to seeking out whether or not there was any heritage interest at that time. So at no point in the 4 years before did the council think maybe this building should merit listing?
We weren't aware of the internal features of the building until it was brought to our attention in the May of 2022.
And secondly, and then I'll invite Mr. Weiss to come in, you said there that the council's aims and its LDP are obviously to conserve and enhance the historic environment. So you felt that Hez should fully consider the listing potential again, and had Hez not already done that? That's what I'm trying to understand. They'd already looked at its potential and they'd said no.
They looked at the potential and said that it merited listing.
Thank you. Mr. Weiss, do you have any comments on this particular matter?
Yeah, as you can imagine, I have more than some comments. Anyway, the whole spirit of the legislation has completely been missed by the council. If we go back to section 3, in particularly section 3.4, a building preservation notice shall cease to be enforced if Historic Environment Scotland include the building in a list compiled or approved on section 1, or notifies the planning authority in writing that it does not intend to do so. And in general, section 3, the council was fully aware that Hess do not intend to list the building. Hess determined not to designate this building, not to include it in any list compiled under section 1. A BPN notice is to be served prior to any Hess decision or any indication or notification by Hess to the local authority as to what their determination to be, primarily a determination of not to list. Hess told the council that they are not going to list the building. The council, prior to Hess's decision, was contemplating the service of a BPN notice. Now, Hess has confirmed on this hearing that there has been no material change between the first case and the second case, apart from a BPN notice, which is not a material change. The advanced planning application were the same, the historical facts were the same, the building was the same, there was no material change whatsoever. The council confirmed that they knew about the demolition prior to Hess's review of the building. They knew about the demolition after Hess decided not to list the building. They were contemplating a BPN notice during the time that Hess were reviewing the building, which, by the way, they could have served the BPN notice during the review period, the initial review period of Hess, and they decided not to do so, even after they themselves visited the site. And if they really thought that the site determined or was of such historical importance, they could have, if they visited on the 12th of July, on the 13th, came back to the office and served the BPN notice. And then Hess, according to them, would have anyway listed the building. But they didn't serve the BPN notice. They didn't follow the spirit of the statute, which clearly says that in the case where Hess informed the local authority, which is Glasgow City Council, that they do not intend to list the building, then a BPN shall cease. And if it shall cease, it shall not be served to begin with. So this whole back and forth about this BPN, this Hess second case, again, the whole thing to me is a mind-blowing sham. And the Court of Session saw this, hence they quashed the reporter's decision. Yes, the reporter erred in law because she frankly didn't take any of these points into consideration. Glasgow City Council, if they were party to the claim, the judges would have determined that they erred in law as well. And those points would be argued in front of the Court of Session again and again if necessary. Again, the reporter's role over here is to come to an understanding and to a determination of why Hess decided to list the building the second time, decided not to list the building the first time, and what changed in between. And frankly, the BPN is no material change, and the BPN itself is an invalid BPN. And even if you want to consider the validity of the BPN, it does not go with the spirit of the legislation, which is what is intended process for a BPN.
Any comments for anyone before I ask a few additional questions? Ms. McDowell?
Yeah, a BPN had not been served before we took our first decision. Therefore, a decision not to list was not material to the BPN, to the status of not listing something in reference to section 4.3.4, that Mr. Weiss mentioned. That doesn't didn't engage anything legally.
Yeah, I mean, that's written out in the court session judgment. There's passages on this particular subject. Ms. Farrell, just to understand further the council's approach here, did the BPN go through a committee process, or was it a delegated process? Sorry, the council still there? Give me a second. We'll try and get them back online. Just one sec. While we're waiting for the council to come back online, I'll come back to the question for them. But Ms. McDowell, if you could take us through HES's processing of the second listing request. So what happened from that point forward?
Okay, so we received an application on the 31st of the 10th. However, as the council said, we had been written to, so we knew that a building preservation notice was going to be served. They informed us on the 31st of the 10th that VPN was served on the 18th of October, and then submitted their application form. In processing the request, we didn't undertake to revise our previous decision. What we did was take a second decision and undertook a fresh assessment. So we looked at what all the information that we had compiled previously, and we needed to check all that and consider more information if it was available to us. So effectively, we were in the process of assessing site as we would any site in our usual way. We referred to our site visit, so we didn't go back to the site, but we did more research. We found that there was some additional information about the name of the architect who was responsible for the design. And with that information, we just updated our report of handling and our assessment. We produced that and we prepared it for consultation. We felt at the point of, because there was a BPN and the policy on the designations of buildings when there are advanced development proposals different in those circumstances. So we proceeded with a consultation to list. We consulted on that proposal on 7th of December 2022. We didn't receive any consultation responses from the Planning Authority as previously mentioned. Effectively, they proposed it for designation. So in those kind of situations, we don't always expect to hear more from the proposer. And we received a response from the owner, Mr. Weiss. We replied, we responded to Mr. Weiss's consultation responses that refer to many of the things that are being presented in terms of the issuing of Craighall not being able to proceed because we had already made a decision. We explained from our point of view what those things meant legally, and that we were in a position to designate. We were aware of the change basically in our policy was we were able to proceed, and we explained that, and that's all explained in our report of handling. So we were clear about the context of the building preservation notice, and we found there was no policy impediment to prevent us from listing. We did find still, several months after our first decision, that there was still merit for listing in terms of the special architectural historic interest of the building. We proceeded to list in February 2023.
Okay, so that's very useful. During that process again, let's talk about inclusion. So at what point was Mr. Weiss invited to provide any response? Was it at the consultation period?
Yes.
Yeah. So I suppose the question is, the decision to list, is that made to the owner or is it made with the owner?
The decision to list is our decision to make. We base that on the evidence that we hear and also the circumstances, that the information about the circumstances of the site that relate to the development context. But in this case, there was a change to the circumstance in which we could designate while there were development proposals at an advanced stage. So the thing that was preventing us from proceeding with listing in the first decision wasn't there in the second decision.
Come to yourself, Mr. Weiss, and then I'll come to the council just to ask a few questions. So, Mr. Weiss. Oh, you're on mute.
I'm just coming in on this point because, again, Miss McDowell did raise this point earlier about the advanced planning application. Earlier in the hearing, Ms. McDowell did confirm the fluidity of Hess's decision-making and how it was up to Hess to determine whether advanced planning application was a factor or not a factor in listing building. So the fact that now she's stating that the advanced building proposals fell away, that consideration fell away because of the BPN, to me is a bit peculiar, as it is within Hess's power to list a building even when there is planning at an advanced stage with no BPN. So again, the fact that only the BPN was now the crucial point in Hess's eyes to list the building, even though nothing else has changed, it is surprising. Hess could have decided to list the building even with its advanced planning application in the initial designation report, yet it decided not to. So again, it's just an important point to stress that all of these things were in Hess's hand, so to say, and the fluidity of the decision-making was confirmed at least once, if not more, by Ms. McDowell. So again, this BPN point, I think a lot of weight is now being retrospectively put on it by Hess in a way to try and to distinct and differentiate between the initial case and the second case. The next point which Ms. McDowell stated is that the only historical fact which came to light was the architect of the building. There is a professor, I can't remember his name offhand, which actually wrote a report about the city sawmills back in the 1960s. And if it was up to him, he himself points out who the architect was. So it is a bit surprising that Hess also confirmed in the hearing they have the access to the best archives, weren't actually aware of George Bell being the architect, especially as they have listed a few of his buildings previously. This isn't the first building of his to have been looked at by Hess itself. So again, I just feel it's important to stress these points, especially when they are brought up time and again, as the weight on the BPN is becoming increasingly more relied upon by Hess and the council, when in actuality, it isn't considered a material change and has had all the evidence before them and the ability, more importantly, they had the ability to list the building in the initial case, even when there was advanced planning proposals, and yet they chose not to do so.
Okay, thank you, Mr. Gregg. I was actually going to come to you. I think you talked about the risk of judicial review previously in terms of had Hess listed the building in your initial decision, but I'll let you continue.
I was just wanting to clarify, sir, that the thing to bear in mind with these two Historic Plan of Scotland decisions is that they were made with different policy contexts. So different parts of the Historic Plan of Scotland policy was at play for each decision. In the second one, you have they've got a particular part of the policy which is engaged when a building renovation notice is served. That was the also that was engaged in the same decision that was applied at the time. So I just wanted to make that point to make sure that was understood.
Yeah, we're going to come back round to that because I want to delve into the wording of those two policies and their meaning. But in terms of that, you mentioned the judicial review risk was a factor in not listing the building when there were advanced development proposals on the site. Is that the same when there's a building preservation notice attached to the building? Is it not the same risk of judicial review?
I'm not sure. Well, I'm not sure it was myself who raised the point about a judicial review risk influencing a decision. I'm not sure that's quite the point that was being made at our end.
Sorry, apologies. Mrs. McDowell, Ms. McDowell said that the risk of JR was mentioned in response to a question.
I was making that point based on where we arrived at now in terms of our policy and practice has been based on cases in the past. So as we develop our policy, this becomes the way we our policy and practice is developed based on previous experiences. And there had been risk in the past of that kind of thing. It's not something that was assessed as a risk factor in this case. What we do is this is how we normally proceed. When there are development proposals at an advanced stage, we don't normally designate, and that's in terms of our consistency and referring to how we normally people have that consistency in the role we have in guiding planning authorities and conducting their duties and managing development. This is where we sit. We act in it and we behave in this consistent way when there are development proposals. And so that's the policy context, unless the policy context is different in the case of a building preservation notice.
So yeah, Mr. Parsons.
Yeah, I think it's about I suppose, a general presumption, a general requirement that we make decisions in line with our policy. I think that's kind of something obviously we'll come back to, but what we will come back to is that in the first decision, circumstances we considered were normal. There were no exceptional circumstances. And so we made that decision in line with what our policy says for what we will normally do. Don't leave it was as open as that for us to simply set aside policy in that first decision. We made what we considered to be the normal decision in the normal circumstances. The second decision was different. The circumstances were different. There was an exceptional circumstance, which was the existence of a building preservation interest. So that to me, it's about, I suppose, we need to make decisions that are consistent with the policy, rather than the legislative, just the legislative background for decisions consistent with policy.
Yeah, that makes sense. A couple of supplementary questions here. So firstly, to the council, could I just confirm, in serving the building preservation notice, did that go through a committee process?
No. There was a briefing to the relevant conveners by the head of planning, but it was not felt that I think our standing orders allowed us to serve such notices without having to go to committee.
Thank you. And when that decision was made, was the risk of compensation considered at all?
Oh, the risk of compensation was considered prior to the service of the notice, yes.
just coming back to this point, I take it Glasgow City Council has their own heritage officers, is that correct?
Yes, I'm Jean, the two house leads.
Yes. And did you do an initial assessment of whether you felt the building had special interest?
Yes, in July 2022 when we visited site.
Okay, so you used that. And at no time during the only correspondence you had with HES during all of this was to confirm that you were both going on site, and HES were aware that you were considering a building preservation notice. But you didn't talk about the building, didn't discuss the building, or its merit at all.
Not in terms of its architectural or historic merit. We took our own view, and then obviously HES came to their view.
And normally, I mean, building preservation notices, as you've already said, are quite infrequently served. Would normally be the case that you would interact with HES when considering to serve a BPN?
I mean, our team hasn't been involved in the service of a building preservation notice prior to this one, so.
And I'm just intrigued to understand. So you wouldn't involve HES in that process at all, then, particularly as it's novel.
Yeah, it's novel, yeah.
Sorry, maybe you didn't pick me up there. Because it's a novel process, as you said, you've never done it before. You wouldn't think to involve HES in that process.
Well, we understood that, you know, they had let us know that the building had been, an application had gone in for them to assess it for listing. And so we understood that. There was correspondence back and forth between the two agencies as there is in normal business between us and Historic Environment Scotland, but we had never been in this position before. So yes, there was normal correspondence between us as a local authority and a planning authority and Historic Environment Scotland. But as you say, it was novel, so there's nothing to compare this with. We got their initial response through their letter of 5th of September to say that the building merited listing, and thereafter we felt that we had obviously made our assessment. We agreed with their position.
Sorry, just for my own note and to get this clarified. So you said there was normal correspondence between the two parties. What do you mean by that? Were you corresponding?
The exact specifics of when we discussed matters with them, their FOI responses as to the exact emails that went back and forth. As I say, we probably mentioned to them that we were going out to site and that we may serve a building preservation notice if we felt that was necessary. That was, as far as I can recall, that was the basis of our discussions.
Right. I'm going to move off this particular line of questioning, go into item 4, unless there's anything else that anyone would like to raise. Mr. Weiss, are you still there? Thank you. If you turn off your camera, I'm not sure if you're still there, so thank you. Okay, so we'll move on to item 4. I take it you've all got a copy of the designation policy and selection guidance before you. Yes, and for Glasgow City Council, the next part of this might not be as involved for yourselves. So I'm going to direct these questions to Mr. Parsons, is that correct? Okay, so the first one's quite straightforward. If you just tell me that the policy and guidance, whether it's statutory or non-statutory.
Statutory.
Statutory, right. And just the process, what was the process involved in approving that policy and guidance? You just talk me through that.
So the designation policy and selection guidance was developed alongside that. So that's the Historic Environment Policy for Scotland, 2018 to 2019. But this followed a kind of extensive engagement campaign, which was called What's Your Heritage, which had kind of been carried out in 2017. So that was a very wide engagement process. But policy specific, the policy was drafted by HES and developed through a series of initial workshops and consultations with internal and external peer groups. and external group. The external groups consisted of stakeholders, including heritage and community groups, professional bodies, planning consultants, local authorities, Scottish Government, and special interest groups. We drafted the policy, and we published the draft policy on our website as part of a formal consultation. Draft was subject to all of the normal impact assessments, etc. Following consultations, we collated and analysed the responses, and we published a consultation analysis report. Isn't before you, sorry, but that is available still on the internet. We can provide that if necessary. The finalised policy was agreed approved by HES and published on the 5th of April 2019. It came into effect at the same time as on 1st of May 2019. We launched the policy and, well, HEPS and the associated policies through the Scottish Government Improvement Service in the form of a webinar, which took place on, I believe, the 1st of May 2019. I don't remember. I was there, but I can't think it was that day, 1st of May. Does that satisfy your questions or anything?
Yes, no, it's for my own purposes to understand what weight to be given to the policy and selection guidance. So it's been through a consultation process. You took account of the responses and you republished it, and it became live in May 2019. So on the back of that, I suppose it is called a policy. It says designation policy, but it also has guidance within the title. So there's two separate kind of meanings to policy and guidance. So I'm just trying to understand, which is it? Is it a policy or is it a guidance? Or does it include both? That's what I'm trying to.
I think there's a document which you can download. It's called the Designation Policy and Selection Guidance. I would say that it consists of two things. One, a policy, so our general approach to making decisions on designation, and two, the selection guidance with the associated annexes, which set out the selection guidance for the different types of designation. I think they can be separated for the purposes of the discussion.
Yeah, no, that makes sense. And so when we talk about guidance, that's not set in stone, is it? Because it is guidance.
That's correct, but the selection guidance is non-prescriptive. The selection guidance is a framework for decision making about special architectural or historic interests.
Okay, so we'll keep that in mind as we go through, and you'll see I've been very specific in the next questions about what things actually mean. So if we can all hop to page 7 of the designation policy and selection guidance. It's both the electronic and the paper copy or page 7. So firstly, I'm asking here, it says on page 7, the code expects that the functions we fulfill are transparent, accountable, consistent, proportionate, and targeted when needed. I think that's come from the Scottish Regulator's Strategic Code of Practice. Could you just explain what those words mean in the context of this decision in terms of its story?
Yes. Well, I think there's probably two things that are worth going into. I suppose there's the way that we consider this code of practice in the formation of policy and selection guidance itself, and then the individual decision-making parts of the code, I think, are relate to the creation of policy, and I'll get into that. But I can go through those. I mean, we're asked to recognise in our policies and practice, and this is the wording from the code, asked to recognise in the policies and practice, committing to the 5 principles, which you've already set out. Our view is that the policy and practice are consistent with the principles of the code, and obviously we'll get into this. The 2 separate decisions we made are also consistent with set out in the code. go through them in one by one. In transparent, we publish designation proposals, and those are available for anyone to comment on. We notify interest parties. We seek and publish views on our proposals to designate, and we provide detailed reports of handling. So we consider that process is transparent. From a policy perspective, we also consult on those as I've set out in the accountable. When we decide to make statutory changes to the list, the decisions are subject to appeal, obviously, both through the appeal process and ultimately through the courts. Policies are subject to public consultation. We're subject to FOI and EIR, and we have a complaint procedure responsible ultimately to the Scottish Public Services Ombudsman. As governance is established to maintain accountability in all the work we do, our governance is published online and set out in our regulatory framework, which is a separate document which was published in 2023. So all our governance is set out online. Consistent policy and selection guidance and our desk instructions, etc., ensure a consistent approach to all cases and provide for robust, consistent decision making. Proportionate, I think this is where it's possibly useful to separate these two things out, but the selection guidance ensures that we're selective in our approach to deciding which buildings to add to the list. So the creation of the selection guidance itself ensures that not everything meets the criteria. We're quite clear that this is a high bar for intervention, a high bar for designation, and that's set out in the selection guidance. We believe that's proportionate. In terms of the individual decisions, we apply exclusions when appropriate, as we have done in this case, to ensure that regulatory processes are only applied when necessary, so to the parts of the building or to buildings where they contribute to the special interest. And for proportionate approach also recognizes the role of the planning authority and the planning process, and we intervene in that planning process only when asked to do so. Targeted is the last point, and that is set out by Don McDowell earlier. Our approach to responding to external requests, focusing on external requests generally, that ensures that our limited resources are targeted to external needs and external interests. So that's what we believe, that the work we do is consistent with the regulatory's code.
Okay, and in this particular instance, when the two decisions were made here, you feel that those both convey those 5 principles?
Yes, that's a review. Yeah.
Okay. Mr. Weiss, any comments?
Yeah, the 5 principles over here. Frankly, I don't believe that the HES process is transparent, as again was confirmed by Ms. McDowell. They decide when they do approach the owners, when they don't approach the owners, when they approach the planning authority, when they don't approach the planning authority. I wouldn't exactly call that a transparent process. Transparent process means that there's a specific document which sets out exactly how things should work, and that process is followed through. This case alone, you can see from the very 2 cases, the initial one and the second one, and the different process which was followed for both, how transparency wasn't the priority over here. That's number 1. In regards to accountability, ultimately the only accountability has is to the Scottish ministers, or as Mr. Parsons did confirm, by an appeals process which can ultimately reach the court. When it comes to freedom of information request, I did file one both on them and on Glasgow City Council. Both of those were transferred under the environmental legislation, which meant that they could virtually redact half of the information given. So accountability, thank God for the courts, otherwise I don't believe they're accountable. When it comes to consistent, it's very evident just from this case alone how inconsistent their consistency is. Which again, I'd be happy to go into, but I believe I've done so with their change of mind within a very short, a few months. When it comes to proportionate, yes, I haven't seen proportionality in either way. In any effect, they were aware in the first instance of the BPN being served. They were proportionate in the fact that they decided not to list it. What is news to me from today's hearing is the only reason they decided not to list it is because they were fearful of a judicial review, and that's why they were heavily reliant on the BPN to actually list it in the second case. That's really my comment about those four particular functions when it comes to this.
Thank you, Mr. Weiss. Mr. Parsons, do you have any comments on what you've heard from Mr. Weiss first?
No, I don't think it's worth I don't want to respond in detail. We issued, I suppose, just on the point of FOI, EIR, this is a very minor point, but we believe that the environmental information regulations were the right regulations to apply to the request. We think very carefully about any redactions. We believe that they complied precisely to the regulations, and the process is subject to review and ultimately the information commissioner. So if there was any difficulty with the redactions, that process was open to Mr. Weiss. But I know that's a detail, but I want to make that point.
Thank you. I think for me, Mr. Parsons, if we can have a look at the first report of handling. I don't know if you have that before you. I wouldn't mind looking at both of them. So if we look at the first report of handling.
Yes, if you give me a comment.
Yeah.
Yeah.
So within this decision, it's very clear, isn't it, at the beginning, the decision is not to list the building because of development proposals which are at an advanced stage. Mr. Weiss, do you agree that that's very clear? Sorry, you're on mute.
Yeah, it's very clear that they did not list it, A, and B, because of the advanced stage.
Yeah. Now, when we look at the second decision, it's now a decision to list. How we've carried out our assessment within policy considerations 3.3, you list the policy referring to building preservation notices. And that's just copied verbatim, I think, from the designation policy and selection guidance. Then there's a section on consultation, the summary of that, and then there's an assessment which is appended. But where is it within the report of handling that that particular change of circumstances between 1 and 2 is discussed?
I think our key point, and I just said that has been clear to everybody. Our key point is that we made 2 separate decisions. We have sought in the first report to make sure that it was clear that we understood there was a discussion about a building preservation notice. We wanted to be absolutely clear that we were making people aware of that. In the second case, we have sought to make a decision against a policy in the circumstances that were before us at that time. I'm not saying, but we think it's relatively clear in the 2 reports. In the honest here, no, that I don't see it as that clear, but we have, I think, set out 2 separate decisions quite clearly. We've set out the policy around building preservation notices, and we have explained that we understand that policy and that we've decided to go ahead with the designation. It wasn't for us a matter of explaining the difference between the decisions, but setting out a view that decisions were, in our view, the correct ones in the circumstances.
I'm just looking at on the face of it though, Mr. Parsons. So the first report of handling, very clear. Everybody here is agreed on that. It's very clear. You're not listing it because there's advanced stage proposals on the site. The second decision doesn't seem to refer to that. It doesn't even say we recognize there are advanced proposals on the site. However, this part of the policy means that in this case, we think we should go ahead and list because there's a different policy application here. And I'm not trying to find you out here. I'm not trying to trip you up. That's not written out plainly here. You just said a minute ago, we think it's relatively clear now. So it might be clear now, but was it clear when this was written to the person reading it, why you came to that outcome?
First, looking at the second report of handling at 2.2, we have explained that there was a live development proposal. That's clear in the second report. We have at 3.1 explained earlier decision and provided a link to the report of handling for anyone who wished to go back to that. We've gone on to set out a little bit about our revised assessment. And then at 3.3, we have set out our assessment of this policy assessment. I think between 2.2 and 3.1, where we refer back to the earlier decision, and 3.3, where we justify this decision, in our view, it's relatively clear.
Well, I suppose that's my point. So I can understand 2.2, it's a fact. You're writing out a fact here. It's background information that there is a planning application live on the site. And then at 3.3, these are facts. These are copied and pasted from your policy and selection criteria. There's no written justification other than the final line. In this case, we've decided to proceed with an assessment of the site and to designate it. So from Mr. Weiss's point of view, he's received one report of handling that quite clearly says we're not going to list it and gives a clear indication why. And in the second report of handling, I'm trying to understand where there is actually any analysis other than just fact and then a sentencing we're going to list it. I'm not trying to belittle it, but I'm just trying to understand where the reasoning is. Ms. McDowell.
I just wanted to say, in terms of the process on the consultation, we replied in detail to Mr. Weiss on we engaged with Mr. Weiss on all the points that he raised, and also in terms of our policy. So we explained that to him directly, and it's not in our practice to publish those comments in detail. We refer back to the sort of the decision-making process in itself, and not the detail of comments.
This is maybe why I'm bringing up the code, because these decisions, should they not be in the public domain, and should they not be transparent and open and accountable, and show the decision-making process? So someone else looking at this down the line, the council said this is a novel situation, it hasn't happened before, would know, well, that's the reason why Hes made that decision. They don't have to ask for background emails that are going between parties. So I'm not trying to catch you out. I'm just trying to understand, is that this report where that doesn't contain the reasoning? What you're telling me is the reasoning happened separately through correspondence with the appellant.
I think we did correspond with the appellant. at the risk of being flippant, were we to write this report again, yes, we would go into a bit more detail. We think we set it out in our appeal response. We sought to set it out in more detail further in our submission of September 24. We sought to explain further that reasoning. We can't, I suppose, retrospectively go back to the report of handling, but we can only explain what we have set out in that. And certainly we will look at that and any other decisions we make. The clarity of that. I don't know if I can kind of go any further to point out what we have done, and to seek to explain any gaps in this area. That's I suppose all we can do.
Okay, thank you.
If I might add, for my part, within the four corners of the report itself, I think it is clear the rationale for the HES decision, in that it takes cognizance of the advanced development proposals that were present on the site. It makes reference to the building preservation notice as part of its own policy, and it concludes that applying that part of the policy, they've decided to go ahead and designate.
Okay, thank you. I have one additional question before I come to yourself, Mr. Weiss. Do you have the Scottish Regulator Strategic Code of Practice in front of you?
I do.
You do? Okay. So I'm interested.
Yes, I do, sir.
Thank you. I'm just interested in the preceding paragraphs after the principles are established. There's reference to the Regulatory Reform Scotland Act 2014 and a duty on regulators to contribute to achieving sustainable economic growth. And I'm just wondering how that duty is applied in these decisions.
I would suggest that our process for creating policy and selection guidance and a robust consultation process is how we have kind of taken account of that. We, I suppose, in our policy, which we've consulted on, set out the things that we will take into account in our individual decisions. For selection guidance to guide our individual decisions. I would say those broad considerations are dealt with at policy level. I think it would be very difficult to do that. Otherwise, I think our policy is quite clear on that. And in consulting with our policy, I believe that's where we have a mandate to make those individual decisions.
Okay, thank you. Mr. Weiss, any comment on what you've heard so far, and then we'll move on to another quotation from the policy.
Yeah, if I can just quickly jump in on a few points. I concur with you that it wasn't clear at all, but just to go back to the point of Hess's fear of a judicial review on the initial decision, and that's ultimately why they decided not to list, because of the fear of an appeal being made on that by a judicial review. I'm sure they'll be well versed that judicial review is primarily based on the Wednesbury test, which is 3 points: lawfulness, procedural fairness, and rationale. Now, Hess knew that Glasgow City Council were intending or were in the process of thinking of serving a BPN. So surely, even under judicial review, it would have been rational, proportional, and lawful for them to have listed the building. So the fact that they didn't list the building with the prior knowledge of a BPN is further evidence that there was actually no material change whatsoever. And the second designation report of handling or case, as you correctly mentioned, didn't even mention the fact that there was advanced proposals and that they're using different policy guidance in order to come to their determination. So again, it is important to stress that we have yet to find a material change between case 1 and case 2. And Hess and the council both have, so far we've been on this call for at least 3.75 hours, and they have failed to find that material difference.
Thank you, Mr. Weiss. Well, I think we might be coming to what might be considered a difference, or at least what's being purported. So let's have a look at, again, on page 7. It says there, we normally avoid interfering unnecessarily in the planning process or other regulatory processes where there are development proposals by adding a new designation. So what I think, Ms. McDowell, you've set out really what that means, that you won't intervene where there's a planning application in play. Is that correct, Mr. Parsons? At any stage, if anybody makes an application, that's the bar?
Policy wording is normally. There is judgment in this, and there is discretion. We seek to explain how we've applied that judgment or discretion, but it does explain our approach in normal circumstances. All decisions are subject to judgment in the individual circumstances of the case. In most cases that we deal with, there are no unusual or exceptional circumstances. And in most cases, we do not designate where development proposals at an advanced stage to us. As set out, in some cases, we may consult with a view to establishing the exact circumstances and status of development proposals. But the point here is the difference between our first decision, where all of the circumstances were normal. We were aware of an advanced development. We were aware that that advanced development required the demolition of the building. We weren't aware of any further complexity other than the council's consideration of the building preservation notice, which to me is very, very different from service of the building preservation notice. In the second decision, were exceptional circumstances. We've all, I suppose, learned this morning that building preservation notices are rare. Prior to this, there had been none since around 2010. They were relatively common through the 1980s and 90s. We don't need to go into that history, but we're of the view that the service of a building preservation notice in this case was exceptional.
Okay, let's move down as well. We're going to move between the two paragraphs. Okay, so we're going to move between the paragraph where there isn't a building preservation notice. So that says that you normally will avoid interfering unnecessarily. So there's wriggle room there. You could have listed the building, and this is guidance. So it's not black and white. Is that correct?
If we consider this to be policy, the guidance is the selection guidance.
Okay.
Those are just words. I appreciate that. This is, yes, in accordance with the legislation may have allowed us. However, I think that we attach weight to our policy, as I believe we should, because we have consulted on it. The legislation is not the only consideration. Policy is what guides the individual decisions. I think it's right that we applied the correct weight to our own policy.
Okay, and then if we jump to the BPN quote, which I've got next on the agenda, you can see that it says that in urgent cases, planning authorities may serve a BPN. And then it goes on to say it's a form of temporary listing, which we've heard from the council. Once a BPN has been served, you have 6 months to assess the building for listing, which we all know. And then you say, we may list a building in these circumstances, even if there are development proposals at an advanced stage. So that's not, again, black and white, is it? There's a lot of wriggle room there.
I suppose, get back to that accountability. We have to defend our decisions to all parties, sides of the argument. For starters, there is wiggle room. Absolutely, we're not that policy allows discretion and judgment. In this case, in the light of that policy, we made a decision to put forward a designation. Yes, that is subject to the application of judgment.
So what I'm trying to understand here is, so the wording in the, when there's not a building preservation notice, is that you normally wouldn't. But when there is a BPN, you may list it. And so that's a subtle difference. It's a tiny difference in the nuance of those words. And you're saying that was enough, those words changing, that was enough. The BPN being served was enough to sway the building into being listed.
Supposed to reiterate the point of the two separate decisions. The one consistent thing throughout is that we believe the building to be a special architectural or historic interest. That hasn't changed at all through the process. In the context of making two separate decisions. Yes, in the first case, we said, is this normal? Is there anything that's exceptional here? Is there any reason why we should list the building? We decided that we should not. The circumstances were normal. In the second case, we were required, I believe, to look at all of the wording of our policy and to make a decision on that, based on that whole policy. We decided that in this case, given the building was of special interest, given the council had sent a preservation notice, given there was no policy impediment to do so, we decided to list the building.
I can't think of a better way to put this, I apologize, but you've initially said don't list the building, and you've said because there's advanced proposals on the site. And those advanced proposals, as far as you're aware at the time, are still in play when the second decision is made. So you've gone, we're not going to list it for this reason. And the council says, oh, but we think you should. And then you say, okay, we agree with you. Is that's I'm trying to understand.
No, I wouldn't put it that way. I would say that there's a very, very specific policy provision, which was consciously added to the policy to allow for designation in the context of a building preservation notice, recognizing that that would be an exceptional circumstance. Through the consultation process, it was consulted on. It was clear during the consultation on the policy that there was a clear desire on part of the stakeholders that we set out the circumstances where we might list, even where there are development proposals. I do believe we did that in the wording of our policy. And I think that policy intent is relatively clear.
Okay, so yes, Mr. Craig.
I was just going to say, in case it's of any assistance, the whole purpose of listing is with a view to the guidance of planning authorities in the planning of their areas. And that's set out in section 1 of the Act itself. So, as I understand it, what the HES policy is trying to do here is it's trying to balance the role of Historic Environment Scotland in managing Scotland's historic environment, and to balance that with the role of planning authorities in managing development in their area. I just mentioned that in case it's helpful to have in mind when considering the policy that's at play here.
Yeah, I'm wondering, as this inadvertently, you say it's an exceptional circumstance. We know it's not that exceptional because I have another hearing next month for in similar circumstances. Has this inadvertently set up a two-stage process now then? So if someone, you can ask for a building to be listed, and if it's not listed, then you can serve a building preservation notice and you can seek a second outcome.
I don't think I would want to speculate on whether we have inadvertently set up a new process. I believe we did two separate requests and made two separate decisions. I don't see a circumstance where we would have refused to make either decision. There was no policy reason, given that in broad terms, there were people out there who sought to have this building listed. We're responsible to all of the parties. We were responsible and are responsible to those who wished the building to be protected, as well as those who wished the building to not be protected. I believe we had two decisions that we're required to make, and that we made both in line with the legislation and the policy. That's our view.
Sorry, we're getting to the end of this particular section. I'm going to bring Mr. Weiss in a second. Just one thing that dawned on me as well, Mr. Parsons. In terms of governance, you mentioned the government's set up with HES. Does these particular decisions, do they go through the governance body, or are they delegated to yourself?
It is the governance that's published on the website. Yes, the decision is delegated.
It's okay, so it's delegated to yourself.
The governance sets out the delegation. Those your individual designation decisions are delegated.
Okay, thank you. Mr. Weiss, any comments?
Yeah, just to come back to the process in which a BPN should not be served. Again, I concur with you that by HES not listing the building, then the council, having served the BPN, does create a two-stage process, which is what I was saying, is not in the spirit of the legislation, especially Section 3 of the legislation, which clearly stipulates that once HES has informed the local planning authority that it does not intend to list the building, the BPN lapses. Hence, the planning authority should not be able to even serve a building preservation notice, especially in the 5-year period, if HES has decided not to list the building. Over here, it didn't even take them a few months. The decision was reached on the 5th of September, and they served it on the 18th of October. Now, prior to that, there is also an email. The HES was aware of the BPN, potential BPN, from the 25th of May 2022, which is, I believe, about 3 or 4 days after they initially opened the case up, and they acknowledged the email from Glasgow City Council on the 1st of June 2022. So again, all this together would again indicate that there still hasn't been found to be any material change between case 1 and case 2. And as you correctly mentioned, that HES's initial decision not to list was done fully aware of a potential BPN. Glasgow City Council themselves, they say they didn't speak to HES about it or its importance. That there is actually a historical trust called the Glasgow Heritage Trust, which Paul Sweeney is actually one of the members of. He's on their board, which again is a great persuader and pusher when it comes to listing buildings in the area. And I'm actually surprised, as Ms. Shauna Simpson, I believe, has been in Glasgow's council for about 11 years and 9 months, according to LinkedIn, and they have never served a BPN. I see no urgency. They have served. They knew since 2018 about the proposals to demolish this building. What took them until 2022, after Hess decided not to list the building, to then wake up and serve a BPN? Well, I suppose she could answer such a question.
Well, I mean, Ms. Farrell, Ms. Simpson, I suppose I asked a question about compensation before, and I think possibly the reason Mr. Parsons has alluded to this, that there used to be a lot of BPNs, and then there was a risk of compensation was introduced. And I wonder, in this case, from what I've ascertained from your responses, the council was given some confidence from the initial HES response that it could serve the BPN without potentially that risk.
Yes.
Well, is that correct? So in your mind, that was one of the reasons.
If HES are the authority who designate assets, so if they were to give their initial view that the asset merited listing, then that would obviously be part of our consideration as to whether to serve a BPN. As you say, the risk of the thing not being listed, if we were to serve a BPN, would be less, because they've taken this initial view that it merited listing.
Mr. Parsons.
I just wanted to, I suppose, clarify our understanding of those points in the legislation. If there is no 5-year period, there is no certificate of intention not to list, that it's really not relevant. I think it's important to just clarify that for the meeting. Further, I think it is, we believe there to be a difference between understanding that the council is discussing something and a decision to be made by the council to serve a notice. They're not the same thing. The council discussing a building preservation notice doesn't very weight in legislation terms. So it's just to pick up on those 2 points. I think the certificate of intention not to list is really not worth discussing further. I think
it's discussed in the Court of Session judgment, so that matter's already been covered. I think Mr. Weiss was careful to say, he said it's not in the spirit of the legislation. So I think he was, and forgive me if I'm putting words in your mouth, Mr. Weiss, I think he was trying to say you made a decision initially not to list, and if that was a certificate, there would be a 5-year period. But in this case, there isn't a certificate, so the BPN could be served immediately, and another decision could be made directly after. Mr. Weiss.
Yeah, just going back to the point. Besides for the Craighall point, it is important to note that over here it is within the spirit of the BPN of the legislation and not the legislation, as you do raise. The Court of Session did touch on the Craighall point, which has been discussed there, as you did mention. In regards to Glasgow City Councils themselves, sorry, I just lost my trail of thought there. Again, they did have the opportunity to serve the BPN, which they failed to do so. And again, I'm still struggling to find the change which caused Hess to really change their mind, which I don't believe anyone has yet to mention.
Sorry, Ms. McDowell, I am going to come to you. I've seen your hand up. Mr. Parsons, is your hand up still because you want to come back in again?
it's just a very minor point on the certificate of intention not to list. 2 points here. One is, the first one is, which we all acknowledge, is we didn't serve one. The second one is we would not have served one because the certificate of intention to not list is served when we consider a building not to meet the criteria for listing. That's the test. The test is we would issue such a notice if asked when we consider a building does not meet the criteria for listing. So I think it's important that that's kind of clear. The spirit or otherwise that doesn't exist.
Okay. Ms. McDowell, and then I'll come back to Mr. Weiss, and then I've got a question for Mr. Weiss after that.
That was my exact point about the certificate.
Thank you. Mr. Parsons, you mind popping your hand down?
Yeah.
Thank you. Mr. Weiss.
Yeah, the point really is that the BPN itself. I am of the opinion that it was invalid BPN. Hess has never confirmed reviewing the BPN and its validity prior to even undertaking the second case. Now, even in correspondence between them, they also never confirmed having correctly reviewed the service of the BPN, having made sure that it's actually a valid BPN. They just undertook the case with the council's word of having correctly served the BPN itself. So again, it's really a question for Hess did they even bother to review that BPN prior to even taking on the second case? They don't mention that in their designation report either of the validity of the BPN. They simply go along with the council's word that a BPN was correctly served on the owners, the occupiers, leaseholders, etc.
So I think I'll revert back to the council here. Is there a bit like an enforcement notice? Is there any? Obviously, the Act sets out how you have to serve the notice, but is there any comeback on that in terms of if it's served incorrectly?
I'm not aware. Excuse me. I'm not aware of the process that could be followed, but the building preservation notice was served by sheriff's officers to those parties that are noted in the legislation, as far as we could find that information. So if there was a challenge to it, then that would be handled as the same as any other challenge to any other notice.
Mr. Weiss, you were aware of the building preservation notice?
I myself was aware of the building preservation notice. That does not mean that it was correctly served. The legislation sets out very clearly how it should be served. And again, the internal emails between Glasgow City Council and their serving agents clearly stipulated that to serve on the owner would cost around £400 and something, which Glasgow City Council initially refused to do. They could have simply, by law, simply attached the notice onto the building and considered that served, which they again failed to do so. In regards to the building preservation notice, in and of itself, that was also a defunct notice. Initially, no indication was on the map. There was information missing on the building preservation notice. And again, this is more a question, I believe, for Hess they didn't even bother reviewing such information, asking those vital questions to validate the BPN prior to taking on the case. So they're attaching this great deal of weight on a BPN, which they didn't even bother asking basic questions from the council. How was it served? Is it correctly served? Is it a valid BPN? And then we'll take on the case. The sheer fact that Hess acknowledged a BPN, which was never served back in September, when the council just told them via a formal email and a letterheaded paper that they have served the BPN, and all they said, right, we'll start to review the case, we'll just wait for you to send it, just again shows the complete lack of transparency, lack of procedure, lack of protocol within the system itself, and their keenness to ultimately list this building. Again, these points are very vital points, because Hess consider themselves to be a very transparent organization, yet we find today that their systems and procedures are so fluid that however you approach it, they'll tell you that the procedure is something else in this case, because every case is on an individual merit. Amazing. You can judge something on an individual merit and have a process and due process to do so, which they do not have. Glasgow City Council haven't served the BPN since 2010. Shauna Simpson herself has been there for 11 years and 9 months and doesn't even know what the legal procedure is to serve a BPN. And she's heading the council's team with regards to a BPN. So frankly, the more and more I hear about in this conversation is the more and more that it solidifies the fact that there obviously was a pressure reply to VA to list this building by external people, which have been evidenced via the Freedom of Information requests, which again were redacted because they changed them, both Glasgow City Council and Hess, to the Environmental Act. But again, I'm repeating these points, and as you can see from more information which both Hess and the council are volunteering to prove my points again and again and again.
So, Mr. Weiss, normally in these circumstances where there's a question about whether a notice has been served correctly or not, I'd ask the question, who, if anyone, was prejudiced in that case? So you were aware of the notice and which building it corresponded to. So what was there someone else that should have been made aware that wasn't involved in that in being notified?
Yes, the building owners and the building occupiers.
Okay, so back to the council. You said the sheriff officers provided that service for you to
So
service
our
the
planning,
people? Yeah.
sorry, Mr. Edwards. So our planning enforcement colleagues undertook the same process that they would do for the service of any notice, and served it in line with the legislation. If it's been served incorrectly, then nobody has brought that to their attention since it's been served. Just to let you know, it's Alison Farrell, who's the team leader for the Heritage Design and Landscape team, and one of Alison's officers.
Okay, and from Historic Environment Scotland's point of view, when you're reviewing a BPN being served and you're being given the task of reviewing the listing of the building over 6 months, do you look at whether it's been serviced correctly?
Answer: no. That is the role of the council to serve a notice. It is a role to tell us that they have served a notice, and it is not our role to kind of examine details of that.
Sure. I mean, thank you. Mr. Gregg, do you have any comment in terms of the generality of the legal point of view that's been put forward here?
I think from the Hess perspective, they're perfectly entitled to take the council's word that they've served a building preservation notice. There's no obligation on Historic Environment Scotland to look beyond that and to undertake some sort of diligence on whether the notice has been correctly prepared and served.
Thank you. Ms. Simpson.
So I'd just like to ask Mr. Weiss the question, if he could clarify in what way he believes that the building preservation notice was not served correctly, because as Shona has intimated, we were not aware of that being an issue, which, with due respect, I don't think is the subject of today's hearing in any event. I imagine if that was the case, that would be a separate matter for the council's legal department to deal with.
Well, yes, I agree with that. I'm just going to say, though, that following the Court of Session's decision, it's opened up a few questions about what I should be looking at. So I'm interested in whether the BPM was correctly served or not for that reason. Mr. Weiss?
Right. So the subject of the valid or invalid BPN, well, you can see from my submissions really throughout since the service of the BPN. In fact, in the council itself, you'll be aware that you've served the BPN at least twice in two different forms. One does outline the buildings which you are serving the BPN on, and the initial one, does not. Thereafter, you didn't serve the BPN correctly on the owners and the occupiers. The leaseholders have never received the BPN. They were made aware of the BPN by myself, and the owners were never actually served it correctly, nor did you ever attach the BPN onto the building, which is a form of service, as you will be aware of any really notice, enforcement notice, or any other notice that a planning authority wants to serve on a building. This has been raised in my submissions. You're welcome to look back where I can quote a few submissions really from the service of the BPN as to its validity. In regards to its consideration of today's hearing, Today's hearing is really, well, it's not my position to tell you what today's hearing is about, but primarily it's to determine the difference between case 1 and case 2 of Hess and why Hess decided to change their mind, which would really inform the reporter to be in a better position to actually quash Hess's decision. Now, if Hess are solely relying on a BPN and that is what changed their mind, and that's what they consider a change in circumstances, then it's important to investigate what this BPN is, what the validity of this BPN, where this BPN even came from. Now, Hess confirmed that they don't frankly look into the validity of a BPN because they don't believe that it is their job to do so, even though they do state that their job is to then open a new investigation based on a BPN, but they're not willing to look if the BPN is a valid one or an invalid one in order to open up the new case. Now, you, the council, are responsible to serve the BPN and are responsible to do so correctly. Now, if you fail to do that correctly, and then BPN and then Hess decide to then list the building on an invalid BPN, so again, the whole thing just falls away, and frankly, there's no need for the reporter to come to any determination because Hess's decision, which is based on an invalid BPN, just falls away and the building is not listed no longer. So that is why the validity of the BPN is core of this case today.
Okay. Any further comment, Ms. Farrell? No. Mr. Weiss, I'm going to take you yourself to the designation policy and selection guidance, and I want to play, for want of a better word, devil's advocate with you here, and put yourself in the shoes of Hez. So obviously in the first instance, I would expect that you would agree with Hez's decision not to list the building because there were advanced proposals on the site. Is that correct?
Well, I would agree with Hess not to list the building. I don't believe that the only reason is because of the advanced proposals. We were both at the building, saw the building, and as I explained to yourself in the site visit, I don't see much history in that refitted building. And as I proved from, frankly, just the change of where the stairs are and the fact that behind the stairs you have the Janet's closet, which isn't with decorated wood because it's not in the public view. I've also made my points very, very clear as to when the refit happened. And I've also made my points very clear on how I know when the refits happen. Because frankly, my family have been involved in this building for that many years. So the fact that now I'm the next generation involved in the building doesn't preclude me from having the knowledge of the previous generations of the building. So by and large, I agree with them for not listing the building. The reasons for not listing the building, primarily, I disagree with it. I don't think there is historical importance in the building. The building has been completely outfit. The roof is a completely new roof, as we saw from the skylights from the loft space. The internal partitions of the building itself have been changed in order to accommodate the jewelers which used to be there, be it with a double entrance in the front, which I did point out whilst we were there with Ms. Dowell and with Ms. Simpson, together with yourself. Again, the staircase being wrongly positioned. And again, you can see where the staircase used to be from the outside as well. From the new boiler room fitting, from the strong room fitting, from the offices of the chief executive, his son, and the meeting rooms upstairs, and the fact that as you go along the building, they become simpler and simpler rooms as were where the workers were, as opposed to where the clients saw. So again, I don't think there is a history in the building itself. Now, when it comes to the history itself, Hess has already designated at least 2 designations in the area, Spars Wharf and the canal as well. They're both designated, which would, in Hess's mind, uphold the importance of the area, of showing the industrial element of Glasgow City Councils. So to list a building from the late 19th century, early 20th century, which frankly has been completely refit because of a few fancy brickwork around the window, I don't view that much of a point in keeping that building, as opposed to allowing the community to have 60 new build-to-rent flats over there.
Thank you. You've jumped down the agenda, but that's fine because I think we are coming to the the kind of final stages of this hearing. We've covered a lot of ground. Could we just jump yourself, Mr. Weiss, just to the part about the building preservation notice when that's served, where it says we may list a building in these circumstances, even if there's a development proposal in an advanced stage. And just putting aside your critique of the building itself and its special interest, do you think that that's enough, that the change in wording is enough, and the fact that the BPM was served would be enough change in circumstances to allow a different decision to be made?
I wouldn't think so. Leave the fact aside a second that Hess was aware the council wants to serve a BPN. Even had Hess not been aware of the council's willingness to serve a BPN and just had to redetermine the building, nothing had changed. Nothing had changed. There was no urgency in the building. This BPN, in my opinion, is a sham BPN. There was no exceptional circumstances. This building has been up for demolition since 2018. Since the council, 2018 is when the council were made aware of the owners wanting to demolish the building. There was no urgency. Urgent and exceptional circumstances means that you act quickly. The promptness test in time when it comes to the legal system, as I'm sure Mr. Gray would attest to, is roughly 30 days. Now, 2018 to 2022 is 4 years. I wouldn't call that exactly urgent or exceptional circumstances. And therefore, in light of that, especially as Hess, in their words, didn't even check the validity of the BPN, there should have been no change in their outcome whatsoever.
Great. Any comment from anyone else before I'm going to quickly review item 4 and see if we've covered most of these points? No, I'll quickly review these then. I think we've already covered. The only one that we haven't distinctly gone into is the 3 bullet pointed criterion for considering whether or not to list, but I think we've covered that in the round today already. So I think the final question on item 4 is whether any of the processes that have been undertaken, whether those would affect the determination of whether to list the building or not in terms of my role. So you're nodding, Mr. Gregg. I don't know who wants to come in, but does anybody think that the processing of these decisions has an impact in terms of whether or not the building should be listed?
Well, if I can pick this one up first, then so my view is no. I don't think the processes that Historic Environment Scotland have gone through, the Hess decision making and the Hess decisions that predate this appeal, are material to your determination of the present appeal today. My view is that the determining factor for present appeal remains whether this building is of special architectural or historic interest. Having said that, it is very important that you understand the Historic Environment Scotland decision making and the justification from the Hess decisions that have been reached, and that you address that in your report, as this is a central issue which has arisen in this appeal, and it's obviously trying to comment from the court session. So I think that you certainly need to address the Hess decisions that have been reached and have gone before in your report, and you need to understand the justification for those. But I think it's a separate exercise to your actual determination of the appeal, which should focus on whether or not the buildings of special architectural or historic interest.
Thank you. We lost the council again, but I'm sure they'll be back in a second. Mr. Weiss, would you like to comment at all on that?
Again, the central point to answer this question really takes us back to the beginning of the hearing. Is the reporter's role a fresh determination, or is it a review process? Mr. Gregg is of the opinion that you are to determine things afresh, as in today. And my position remains the same, that your role is really to review what's been done. Not from today, from when it was done. And therefore, yes, you need to have consideration to why HES did what they did. But in having that consideration, you also need to come to the underlying fact of what changed between case 1 and case 2, which I personally have failed to hear from HES. What has changed? The BPN, which they claim is the change, and that they rely so heavily on, well, frankly, it's not a material change within the circumstances. They were able to list it in case 1 even without a BPN, and they were able to not list it in case 2 even with a BPN. So to say that that is the material change, in my opinion, is incorrect and invalid, and that alone is open for judicial review, because that change is an irrational change of decision based on the BPN alone. And therefore, really, your role today, as set out by the Court of Sessions, is a broad role to review what's been done and come to a determination whether to dismiss an appeal or uphold an appeal. If you uphold an appeal, then your instruction to HES is to remove the building from the list. If you dismiss the appeal, then again, your role is not to instruct HES to do anything because they've already done it. And that alone is sufficient proof to show that your role is to review and not to determine afresh today.
I'm just reviewing the Court of Session judgment there at the end, where it says, the more important point is that the thrust of the appellant's concerns was that they had been treated unfairly by HES. The reporter should have recognised that this was an important issue to which she had to give full consideration. She erred in law by failing to do so. The appellant's various other submissions add nothing to the substance to this analysis and need not be separately considered. So just drawing on that, Mr. Weiss, is that not just directing me to look at the fairness of the process rather than indicating whether or not I should or shouldn't direct that the building be listed or not?
That in turn would direct you to review the decisions, which in turn would mean that you're looking at their fairness. You cannot look at fairness afresh. You have to look at fairness in retrospect, which means review. So what the Court of Session is essentially telling the new reporter, i.e. yourself, to do is to reopen the case and look at what has happened and determine why it's happened, and as a result, accept the appeal or dismiss the appeal. But you have to look at the fairness of the case, what happened within the case. That is that is your role as determined by the Court of Session.
And that's what I'm trying to tease out of everybody here, that if, let's say, for instance, that I go out today and I do write up the section as Mr. Gregg has advised in terms of this point, and I find there was unfairness, but I find that the building still has special interests, where does that lead me to?
That would lead you to uphold the appeal, because it cannot be that you find unfairness, yet you decide to uphold the listing. If there was unfairness, that means that HES's initial decision is upheld and their second decision is dismissed. Because of that, the only way they reach their second decision is due to unfairness. So by you determining that there is unfairness and not due process here, would by default mean that you've accepted the appeal and upheld HES's initial decision, which would result in a direction to HES to remove the building from the list.
Okay, and in that scenario, is there a period of time where the building can or cannot be reconsidered for listing?
In my opinion, they will not be able to serve a new BPN, as it's not within the spirit of the legislation. HES has told them that the building is not to be listed. I am aware that the other parties will disagree with me, as they base their BPN solely on the coin till. But again, that's up to something which which, if it comes to it, the courts will have to determine. But your role today is to determine the unfairness of Hess's undue process, and thereby allowing the appeal, which means you uphold Hess's initial decision.
So just to help me in this situation, Mr. Gregg in particular, so the Act, the Planning Listed Building Conservation Area Act, and its associated regulations are setting out a particular set of appeal grounds and, I guess, tests for myself in terms of whether the building should or shouldn't be listed. But you seem to be introducing what I can only describe as common law. So in terms of the fairness of the process, is that correct? And Mr. Gregg, is that a reason that I could dismiss the appeal, or allow the appeal and then dismiss the listing?
Well, my view, sir, is that your determination of the appeal should be based on whether or not this building is of special architectural or historic interest. That's the grounds of appeal which are set out in the regulations. The issue of the fairness of the Hess decisions that have gone before, that's an issue that you have to address and you have to turn your mind to, but it's not, in my submission, material to your determination of the present appeal. It's a central issue that's at play, and it needs to be addressed. And it shouldn't, I would suggest, influence your ultimate decision here.
Any other comments on that before we move on?
No, sir.
Oh, yes, Mr. Parsons.
You just asked a question in passing about any timescales, but our understanding is if you direct us to remove the listing, there is no statutory time limit on the building being reconsidered. It doesn't prohibit it's looking again. I'm not saying that we would, but there isn't anything that would lead us to not be able to look at this again. There isn't failure limit or anything like that.
Thank you. Now it's getting close to lunch. We're just going to press on because I think there's just a few questions here, and then we can all grab a sandwich. So the appeal building its setting, I take it, is there any continuing dispute over the statutory address of the building, or is that resolved? Mr. Weiss?
Well, it was the city sawmills offices. It depends which part of the building. It definitely wasn't their head office. That I think is agreed that the head office was at 127 Craighall Road. It hasn't been the city sawmills for a long time. So to still call it the city sawmills, I also think is misleading.
Any comment from Hez before I move on to the next question?
No, I would just say we refer to it as the former office building for the city sawmills. And doesn't make a difference to its list, the reasons for listing. We could change the name and, it'd still be listed for the reasons why we've put forward for its merit.
Yeah, it's the statutory address that's the listing itself. So it'll be 124 as its address.
Craighall Road.
Yeah. Yes, thank you. Now, Mr. Weiss, you've given me a lowdown of all the parts of the building that you feel are not of special interest, talking about the roof, internal partitions, the double entrance, no timber in other areas, staircase located in the wrong position, the strong room that was fitted, that the fact that the rooms get simpler as they go from the workers to the clients, and there's other designations in the area that uphold that industrial heritage. And that the decorative brickwork, which you're acknowledging it does have, isn't enough for it to have a special interest and be listed. Is that correct?
Yeah, that is correct, but it's not only the interior, which in my opinion has no historical merit. It's also parts of the exterior which have no historical merit. For example, we saw that the windows of the ground and first floor were also newly fitted windows. We also saw that the part, I think it's to the west of the building, which used to be over there, is demolished, and there's new brickwork on that face of the building itself. So it's not only the interior, which I'm coming to say isn't special. There's also parts of the exterior which aren't special. So again, it's the inside and the outside which I don't view as such historical value. And when it comes to upholding the industrial history of the area, as you did mention, and we actually went along and saw on our site visit, you already have a number of listings in the area which have been sufficiently kept and upheld and maintained to show that industrial heritage. To keep a small chunk of building on such a large plot of land, and again, to because of that, avoid building 60 plus flats, which ultimately are made to rent for the local community, I find that absurd.
Okay, thank you. I mean, I have a submission on the special interest within the report of handling. So I think what I'm interested in here is more to do with the refitting. I'm trying to understand when I looked around as well, and I looked at some features and they were pointed out to me. So if we could talk about first the vault that was installed, is that of any special interest in terms of HES's opinion?
The vault from the 20th century for the jewelry?
Yes.
No.
And is HES content? And I know that there's been correspondence with the previous reporter in terms of the timber and the quality of the timber in the building. But are you convinced that the interior is original and not, for want of a better word, a series of props that were introduced at a later date? They may be original, but they may have come from a salvage yard or somewhere else. You're convinced that these are original and they're part of the fabric of the building.
My experience and knowledge of buildings of this date and this type leads me to believe they are certainly of the period, and it's consistent with the use of the building and the relationship with the history of it being a timber merchant's yard. We know that it was a place where they were using all kinds of different expertise and design to advertise the business. It's very consistent historically as well as in design terms for the period. The patina on the timber work, I suppose it's wear, and also the level of design is very much part of what I would understand a late 19th century interior to be. We know it was an office for the trade. They have it would make sense that there will be parts of the building that would be more elaborate than others. Certainly on the number of occasions that I was visited, I would perceive even more, just by seeing more of the building and having more time with it. I feel like there hasn't been much change. If not, and if it had been replicated, it's been replicated in terms of retaining the character of that building as designed originally. In reference to the stair doesn't appear to have changed, in my view, in its location. I think some elements might have been updated or reconfigured on the outside at the lower level. In my experience, buildings that were used for offices like that would have had sort of like a counter or things like that where you might get payments, or it could have been that's like a storage underneath the stair. I feel like that's something that could have been just made to look part of the building later. But I mean, it is all part of a piece. I just feel there's on balance the level of detail on the interior is sufficiently special to merit designation, and coupled with the fact that it's a brick industrial building that uses more than your normal detailing for a building of that type. The polychrome, meaning different colored brick, the way the brick is formed, the location is very critical to where that building is. I know there's a setting question here, but it's related to the timber basin. It was the biggest trade area in timber in the whole of the UK, and when it was in its heyday. So the fact that it still remains is an important feature. There is no limit to what we can list in terms of there's sufficient, in terms of an argument of there's sufficient recognition of the industrial heritage of that area. It only enhances the fact that there is a timber basin, scheduled monument of national importance in which that timber trade took place. The survival of the building in that context is critical to it being designated, and in fact that it has an interior of interest adds to that interest.
Thank you. Yeah. During this conversation, I'm conscious that Mr. Weiss, you said right at the beginning, and indeed in your submissions, that this property has been in your family for some time, and that you have recollections of visiting there at a younger age. What's your understanding? Are you telling me that it was retrofitted in the 90s? Is that correct? And these design elements were incorporated at that time?
That's correct. Respectfully, Ms. McDowell's thoughts is a hypothesis. She's coming from a historical element where she does not know the facts on the ground, and she's built a beautiful scenario and a story based on the few facts which have been available to her. For example, that it's being the largest timber merchant in the UK at its heyday, that it was part of a 14-acre site, etc., etc. The importance which I attach to the statutory address of the building is precisely for this point. This was a former office block. It was not the head office. When we started this question, Ms. McDowell did confirm, well, she agreed with me, that the head office was at 127 Craighall Road. Now, if you open the OS maps of 1956, later and earlier, you'll see where 127 Craighall Road was. It was right by the timber basin. Now, when customers came to see their head office, you would imagine how decorative their head office at 127 Craighall Road. And in my opinion, if anything should have been listed, should have been 127, which was the head office, not the former office building. Now, I'm not sure what research Hess or the council has done in regards to Henderson, the jeweler, which was a very large Scottish jeweler. In fact, they were the manufacturers of Macintosh jewellery, which I'm sure everybody is well aware of Macintosh and his designs. They were the sole producers of his jewellery in their heyday. They were a very large company, and they had what to show when customers, clients, buyers and sellers came to their head office. The double-fronted entrance, which Ms. McDowell claims may have been or may not have been used in the timber merchant to accept payment, that wouldn't have been located there. Ms. McDowell herself admits that that west part of that building was demolished. So why would there be a building which you come into and then you have the payment office? So again, this hypothesis is very nice. It's beautiful if we'd be talking in 200 years' time with no one having any recollection of what the building was or was not used for. But I'm speaking from facts. I know of the retrofit. I know what the building was used for. I saw it myself what the building was used for, what the use of the building was, who the building served, what purpose did the building serve. Again, these facts are openly available on the internet as well. You can see from the planning applications when the roof was added on, when the windows were added on, when the later building was added on. You can research yourself who Henderson the jewelers were, how large they were, what kind of jewelry they manufactured, what kind of prestige did they show. They had shops on the seafront, in the high streets in Ayr and Kirkcaldy, and the main high streets of Scotland at its heyday. They were a large jeweler manufacturer which had what to show. And yes, of course, they also, just like they produced Macintosh jewelry, which was heritage to the natives, to the Scotland, they would also uphold their office building to its history, which was the timber merchants. Of course, they would do that. And they had the money to splash in order to do that. In regards to the stairs was seen is bang in the middle of a window. Now, George Bell, we all agree, was an architect of its time. He wouldn't slap a staircase in the middle of a window, nor would he put a toilet where the main entrance to a building was. That main entrance, the external entrance to the building, is sealed shut yet kept, but behind that is the toilet. He would not put the boiler room over there and shut it up with brickwork. So again, to come along and tell me that this is all woodwork from George Bell's time and from Brownlee's timber merchant times, lovely. If we're talking 200 years time and you're giving me a nice hypothesis, but we're not. This isn't such an old building, and there are people which still remember what the building actually was used for. And these same people which saw the building being used, i.e. myself, is conveying to you the facts which were on the ground.
So just to confirm, Mr. Weiss, for my understanding here, your family, were they the Henderson Jeweler Company?
They were not, no. We were suppliers to the Henderson Jeweler companies.
You're suppliers to that company. Okay. And right. And they were situated in that building.
That was the M.M. Henderson's head office, yeah. Okay,
it was their head office. And you've described to me their history and the fact that they were prominent producers. They were prominent in the high streets of Scotland in their heyday. And for that reason, they would have respected the history of this building and they would have fitted it out in a way that mimicked what the building was used for in the past. Is that right?
Yeah, they had enough funds and they were a big enough establishment to have the funds to retrofit a building to exactly their specification. As when we went around the building, I showed you where the chairman of the company, the head of the company, used to sit. That is the most lavish room in the building. His son, which was second in command, sat in the room next door, and that again was a very lavish building. Yet when you went to the bathroom of that building, it was extremely simple because clients wouldn't enter that bathroom. They would enter the other bathrooms. Where I showed you the sorting staff would sit, be it on the first floor and the ground floor in the back, those were super simple. They were super simple rooms and offices. So yes, the reason why, again, was important to have that site visit was to walk you through what a regular day in an M.M. Henderson head office would look like, where I walked through when I went, as a child to see Mr. Henderson himself, to see Mr. Henderson's son himself. So again, I'm talking here from facts on the ground and experience, not from some hypothesis.
Okay. And is there any forgive me for saying this, but is there any evidence that's been submitted, either photographic or documentary, to show that it's been a retrofit rather than being original?
I haven't submitted such images, primarily because I haven't found those images. Again, you're talking about retrofit from the 1990s. This is from my early days. I may look young or not so young, but again, I have a recollection as a child of going there and seeing the office, and it's been evident the use of the building and how they used it, and again, their stature of the retrofit of the building. It would make no sense whatsoever for Brownlee to have fitted former, again, Hess called it a former office building, but it was part of an industrial location. The office building was actually in 127 Craighall Road. Again, if you do look at the OS maps, you will actually see that the whole complex, including the wholesalers next door, was also part of the Brownlee estate. And that whole complex was actually to process the wood, which would come from the timber basin. Mm-hmm. So it makes no sense for Brownlee to have invested that amount of money, detail, and complexity in a mere office building which processed woods.
Mr. McDowell, any comment from what you've heard in terms of Mr. Weiss's personal observations of the building?
I think even if the building has been done in a retrofit that's in keeping with the the heritage or the history of that building, that's something that is a factor in our decision making. So the replication is very good. Whether it's original, I disagree with because there's no evidence of it being completely refitted. And if I was to encounter that building without that information, I would have taken it as something that is very well from the date of the construction. It is very unusual for a building to be refit to that level, to that degree. We would have some knowledge of what kind of refit that was, because it's extraordinary if that's the case. And I would find that very, very unusual.
Okay, well, I think that's something for me to come to a decision about. In terms of that heritage that you've heard about, was that something that Historic Environment Scotland thought about in terms of the jewellers having owned the property?
I think it adds to an interest of it being, used as a commercial premises. We understood it to be part of that use. It seemed like a use that wasn't completely didn't completely change the plan form or the organization of the building mostly. There was lowered ceilings, things that were inserted in bigger spaces, some partitioning. You could still understand the building as a building from the turn of the 20th century, in its plan form and in its sort of material quality.
Okay, I think I haven't written submissions parties comments in terms of the historical link to Brownlee. So I think we could pass over that unless anybody has any further comment about that particular link. No. No. Talked about the Spears Pier warehousing and the sugar refinery in the Forth and Union Canal scheduled ancient monument. That's agreed with parties that's part of the wider setting of the building. Is that correct? Yeah. Now, any other buildings that might form part of the setting of the building or the wider heritage? At the site inspection, we visited St. Teresa's entranceway. Does that have any particular relevance?
Shall I answer that?
Yes, thank you. Okay.
It's not directly related to the timber function or the function of that building. It's a historic building in the local area that it is just in terms of that, it relates to the history of the north side of Glasgow. And there are other manufactories and buildings of that type interspersed now because of so much loss of buildings within that area. It's very common for you to then have a sort of dotted around listings of buildings. It's not directly related to the timber merchants and the use and the function of that building. But I would say that the connection to the canal is the most significant, and the other warehousing that's just predates the office block. Obviously, Brownlees were there from the mid 19th century when all of that was in complete use. There's a timber merchant's yard there now, which is fact, and which is interesting. Across the road.
Okay, well, are there any other matters that anybody would like to raise?
The Forth and the timber basin itself, as Ms. McDowell said, is already a listed monument as well, which is directly linked to the timber merchants. It's funny that Ms. McDowell mentions the Jewson's timber merchants across the road, which is in a completely new style warehouse and has nothing to do with what Brownlee would operate from. So it's funny that he does sit on the former head office of Brownlee's timber merchants. But again, if they would, if they want to uphold that, they can list the Jewson's, building. If you really want to uphold the timber connection to the area.
Okay. Are there any other points that anyone would like to make? Now, I did say it would afford parties the opportunity to give a short summary of their case if they think that that would help them. Would anybody like to do that?
No, let Mr. Craig have the honors.
Thank you, Mr. Vice.
It's not a requirement. It's just whether or not anybody would like to do it. So if you don't, I mean, I have a very comprehensive set of notes here. The hearing today has been filmed. You can watch it back. So there is a record of the meeting, so I could easily look at that for a summary of your cases.
I think you have our position on all the matters we've discussed, sir. You know, the headline view from Historic Environment Scotland is that your remit here is to make a fresh determination based on the evidence available to date. And you should also, as part of your decision, address the Historic Environment Scotland decision making that has gone before. We understand that the criticism of the previous reporter that was levied by the court was essentially a failure to properly understand and interrogate the Historic Environment Scotland decisions before. So that will, in a sense, will need to be done, but there's no material to the ultimate decision that you need share. So hopefully that's that.
Thank you. Glasgow City Council, would you like to say anything before we sign off?
I suppose really just to emphasise the fact that listing in itself shouldn't preclude development on the site in any event, and that NPF4 in terms of planning has a presumption against demolition in any event. In terms of the competency or not of the BPN, that to my knowledge has not been raised with us as yet, so that's something that we can discuss with our legal advisors. Yeah, that's it.
Okay, and finally, Mr. Weiss.
Thank you. I'll try and keep it brief, as I believe I have expressed my views quite clearly. Correct me if I'm wrong thus far. I'll start backwards. In regards to the BPN which the council raised, they will be well aware of its validity or not. They can see that on the email correspondence. They can also see that there was turmoil within their own legal departments as to how to survey BPN. But again, I know that because of the emails which they sent to me, so they surely should know that. In regards to the remit of the reporter, i.e. yourself, Mr. Edwards, besides for the direction which you received as a new reporter from the Court of Sessions to really try not to err in law and to take all of the considerations into play over here, it's really to determine the appeal and to understand why HES changed their decision, what material change there was here, and the fact that there was no material change would essentially mean upholding the appeal and instructing HES to remove the building from the list. I think it's also imperative to understand what exactly collusion went on over here between HES, Paul Sweeney, and Glasgow City Council, as it also plays a vital role in understanding what the apparent change was. We're talking about very short time scales here between, a decision not to list, a service of a BPN, and a decision to list. We're also looking at procedural errors which occurred within HES itself, within Glasgow City Council itself, namely HES, just changing consultation periods at their own whim based on requests from Glasgow City Council. Glasgow City Council itself, you can see the emails between themselves and Councillor Go, where he asked him why on earth he served this BPN and how come it didn't come to the committee stage. And Glasgow City Council, frankly, misleading Councillor Go. This is all evidenced in my submission before the Court of Session, labelled TL10, which is before everyone as well. So again, it's just to come to a full understanding of what's gone on here, why this has happened, to uphold the appeal, and remove the listing. Now, I believe that there's sufficient evidence before the reporter to do so, besides for the fact of the lack of historical importance, as I mentioned, of the building, be it retrofitted, be it not actually being the former head office of Brownlee's Timber Merchant, the fact that there are already monuments in the area which uphold the industrial past of the whole timber basin and Forth and Clyde Canal, the fact that there are economical benefits to the local surrounding areas. There are going to be, it's a build to rent scheme, which is going up of 60 plus flats, etc. So again, just weighing all of these things up should really lead yourself, Mr. Edward, to the determination that Hess's initial decision not to list the building was the correct one. And their second one to list the building, not only did it err in the way that it came to that decision, there was no material change whatsoever. And even if they want to consider the material change as being the BPN, they never investigated its validity. And even in the event that they did find it to be valid, they still had the opportunity, based on their own policy guidance, not to list the building due to its advanced planning proposals, which were in force. So that really concludes, I believe, my submissions at the hearing. And I believe I've been clear thus far. If you have any other questions, I'd be more than happy to respond to them.
Thank you, Mr. Weiss. That was quite a succinct summary from everybody. Just one thing, Mr. Sweeney, Paul Sweeney, is not here. He's not at this hearing. So I'm a bit concerned about using the word collusion where he's not here to defend himself. And that wasn't a theme of the discussion. I know you talked about pressure being put on certain parties, but the word collusion, I don't know if we want to strike that from what you said and just say, I don't know, your understanding of what you were saying there.
Again, the way I feel towards it, which again the Court of Sessions did pick up as an undertone, quite a strong undertone, as that is what they found that the previous reporter erred in law and didn't take into consideration. The evidence is pretty clear. I mean, the emails are there, the discussions are there. So it's not like I'm coming into the hearing today and coming to accuse somebody or coming to accuse some innocent party. I'm not doing that. I'm basing my knowledge on fact. The emails between Glasgow City Council and Hess about their intention to potentially serve a BPN, the fact that the first initial application was redacted and then it became unredacted during the process. The emails between Paul Sweeney and Hess, Paul Sweeney and Glasgow City Council constantly chasing this up and trying to pressurize them. Again, I don't have, those are the emails which I have. The emails which I don't have were redacted because it was changed from a Freedom of Information request to an Environment Act request. I would be happy to be proven wrong. I don't mind. But as things stand today, I would call it collusion.
Okay. Mr. Gregg?
Just to remind somebody, this government is going to refute any allegations that there's any sort of collusion or impropriety that's going on here. There's no evidence of that.
Was the Glasgow City Council for the record here?
And on the building preservation notice side of things, we just made the point that as a public notice, it's valid until set aside. There's been no attempt by anybody to seek to reduce or some wash the building preservation notice, which was served. Just these 2 points.
Just to come in on the building preservation notice, in fact, there was an attempt to do so. There was correspondence between myself and Glasgow City Council to that effect. Hence, Glasgow City Council felt the need to serve a second building preservation notice. As far as building preservation notices go, you cannot just apply to the court to set it aside under an injunction of any sort, because it is actually attached directly to the statute, which gives Hess and only Hess the opportunity to quash such a case by not listing the building or it lapsing after 6 months. So for Mr. Craig to suggest that it's subject to a court injunction to set it aside is frankly incorrect. And the suggestion that there was no attempt to communicate with Glasgow City Council as to its invalidity is also incorrect.
No, it's kind of protracted the argument here, but just to say that it might have been possible to seek a judicial review, but if there was some sort of in the service.
Yeah,
But in any case,
just to come back on that, the judicial review process of a BPN, especially the speed in which Hess actually acted, as you can see from the chronology in my notes of argument to the Court of Session, would actually be for Hess to determine to list or not to list, and then to appeal on that. The statute is very clear as to the process when it comes to listed buildings or not. So to suggest that a building preservation notice would have been open to a judicial review when Hess acted that quickly on it, Hess didn't wait for 6 full months and then decide on the last day, oh, you know what, let's look into this. It was given to them on the 31st of October, and on that day they opened the case.
you have my points in that, so if you've got any further questions, I'm happy to address those.
Okay, no, that's fine. Thank you. Well, all that remains is for me to thank you all for your participation and helpful discussion today. Following this hearing, I'll write up the decision, which will be issued ahead of its target date, which is the 9th of May this year. Are there any final questions about procedure? No, in that case, thank you very much for your participation today, and goodbye. Hope you have a good one.
Thank you. Have a good day.
Thanks, sir.